Can I just say something about Andrea?
Well, hey everybody, welcome back. Welcome back. Did you have time to relax a little bit? Sit back, clear your mind, get some deep breaths. Maybe pour that little nightcap. Not me. Not me. I'm too old for that kind of thing anymore. But yeah, I just I find it can be helpful sometimes to kind of sit and let things simmer a little bit. Um, we all kind of have our knee jerk reaction to what we see in a day of court. Uh, but just because it's the instant reaction doesn't mean that it's the right one. And sometimes it's good to just sit and kind of ponder, maybe a little bit more leisurely, what it is that we saw today. So that's my goal for this recap. We all got to watch the hearing, so this isn't a situation where you need my notes to walk you through what happened. There's no other source of information. It's not that. But it's not like I'm going to break my habit of taking all the notes anyway. So we'll do a little bit of both. Why not? We watched the hearing earlier, and now we'll just come back and talk about what we saw. So, if you weren't able to make it this morning, you can tune in on the earlier stream for the source, or you can just get the overview 10,000 foot with my occasional meanderings into the stuff that caught my attention and seemed interesting, and like, ooh, I got to follow up on that. You can follow me on my little journey through how today's court hearing went. So we are, of course, talking about the first day of the Tyler Robinson preliminary hearing. It's surely not just me. It feels like we've been waiting on this forever. It really does. Yes, it's a death penalty case. Yes, everything takes longer, but just 10 months to even get to the preliminary hearing is kind of wild. It really is kind of wild. Normally, these things take place in like 2 weeks. 2 weeks from arrest. Maybe it's a complex case, a lot of discovery, so we push it out a month. 10 months is kind of wild. But we know there is a massive volume of information. We know there's a lot they've had to deal with. Easier, I guess, to just avoid any kind of problems, any kind of concerns about, oh, you didn't turn that over. Oh, we didn't have adequate time to review that. Just cut all that off by giving them the time that they want. But you can't delay the inevitable forever. And so today was the day to get it started. We started with everybody stating their appearances for the record, but then we also got a special recognition of Erica Kirk present in the courtroom from Judge Graff. Take note, I mentioned this in the live stream. Erica is not the same as all of us when it comes to this proceeding. Erica has more rights than we do. Utah Constitution grants them to her. She is a victim, the representative of the direct victim, Charlie Kirk, in the case. And so because of that, she is going to get some special acknowledgement and special treatment from the court that nobody else is going to be entitled to. I don't expect her to abuse that or take advantage of it or anything like that. There's been no indication of anything like that so far, but she certainly does intend to exercise her rights, has done so, voiced her preference for speedy proceedings to the extent that that's going to be possible in Utah. So I definitely noticed that. Judge is going to specifically acknowledge Erica Kirk on the record. They are going to show her the highest respect and deference and courtesy. That is often the case, but I feel like here we are in Utah. This is the nicest courtroom I have ever seen everybody is just so polite. Everything is so cooperative. It's just so calm. The vibe in this court is wild. But the respect and the acknowledgement to Erica Kirk, I kind of feel like that plays a part in it as well. Just there's a cultural issue at play there. He started by addressing a renewed motion that was made by the media to be exempted from the order that he signed, saying that he was basically going to ban devices, electronic devices, from the courtroom. And it's largely because, you know, if everybody's got their cell phone in there, they're not going to be able to control, like, is anybody recording illegally or anything like that. So the easiest thing is to just keep them all out. The media wanted a special exemption for themselves. Judge Graff said, nope, we're not going to do that. However, as far as the attorneys for the media goes, because they are officers of the court, as all attorneys are, he will go ahead and allow them as well to have their devices in the court. I appreciate that. I think it shows foresight on his part, even though the involvement of the media's counsel today was pretty minimal. Nevertheless, it wasn't zero. And we can anticipate a situation where there's going to be some kind of conflict, disagreement, argument about what should be publicized and what shouldn't. And as a lawyer, you often need your laptop in the courtroom so you can look up your case, you know, give them the citation and things like that. You can be a real fish out of water without access to your law. It's kind of like the thing this is all about. So when you can't get to it, you're just not going to be very helpful as an advocate. So it makes sense for him to provide that exemption for counsel, but was not giving the media any kind of special dispensation to live tweet from the courtroom or anything like that. Reviewed his basic decorum order. The bottom line, guys, is just be good, be classy. This is court. Treat it like court. If you don't know court, treat it like church. It's similar kind of environment. You're there to show respect for what is going on. It's not about you. So just consider your presentation accordingly. Took the time to commend everybody. They've gotten to know each other over the last 10 months. Everybody is competent, prepared. They care deeply about the case. And just reminding them, to the extent they need it, behave with civility and decorum throughout this process. And please be mindful of the constitutional rights of the parties. This isn't, I mean, this isn't like a warning. I didn't really take it as a warning from the judge, but I mean, this I think is pretty clearly directed at the state, just in terms of, you know what you're here to do. Everybody knows what the standard is. We don't need to showboat. We don't need to get into things that are irrelevant. We don't need to get into things that aren't admissible. We don't need to inflame the situation. Lots of prosecutors, you might have to be concerned about something like that. Really haven't gotten that take from this team at all. If anything, like, they need to turn it up, turn the excitement up a little bit of a notch. Not go crazy or anything like that, but you know, you do run the risk of having a lulling type of presentation. You know, you got to know when and where to grab people and with what. It's great to have the lull, especially for all those dull, uninteresting parts of court that are going on. But you got to know when to turn it up when it's time for me to get your attention. So we'll see. We'll see if they have that gear. To the extent that there are objections that need to be addressed outside of the view and hearing of us, the public, because, you know, arguing it in public would kind of give away the issue, then he invited them to the bench to do that. Schedule-wise, the 1 hour lunch at noon and finished at 5 p.m. he did hold to that. We finished a little bit early today. Nobody, defense or plaintiff, wanted the benefit of the record. I love that expression that he's been using. Would any of you like the benefit of the record? He's just inviting them to say anything that you want documented for future review purposes. Do you have anything you need to bring up? Now would be the time to mention, for example, yeah, I know you gave us this extra time to prepare, but we're still not ready. We couldn't get through everything. This thing came up and then I got sick. So we really need to ask you to continue it again. That's the kind of thing this benefit of the record is inviting, but nothing. So then asked if anybody's invoking the rule of exclusion, general rule that if requested, witnesses can be excluded from the courtroom while the other witnesses are testifying. So there's no temptation to tailor their testimony, alter things to make sure it's consistent with the last witness said. Everybody's recollection needs to be independent. The exception to that is agents David and Hull get to stay in the courtroom. They are the lead case agents. Like, still having a hard time saying this with a straight face. They're the lead investigators. Okay, we're not playing this Massachusetts State Police word game. Okay, the case agent. Fine, maybe that's the official title. It doesn't. They're the lead investigators. Okay, that's what matters. At least they were at the time. Mr. Novak did his only appearance, his only speaking up all day. Mr. Novak did remind the court that as far as the publication of the exhibits went, that court had kind of said we're gonna take this up on a case-by-case basis. Judge wants to know if there's any stipulations vis-a-vis things being admitted, things being published. No stipulations from the defense. This is not shocking. It wouldn't shock me if they did, but it doesn't shock me that they're not stipulating to anything. They really can't. And now we see as the hearing gets underway, why? Because you have to object to all this stuff. And so if you stipulate to it, you're potentially waiving your objection. So objecting is more important than stipulating. So they did meet and confer. However, everybody agrees 7, 8, and 9, exhibit 7, 8, and 9. These are video evidence. They are graphic, and that they did not intend to publish any of those exhibits to the monitors in the courtroom. However, the judge says, yes, he's going to entertain all motions vis-a-vis the exhibits. However, there is a benefit to publishing certain exhibits, but doesn't necessarily want them displayed on the TV. So the judge would be seeing them, but doesn't mean that putting it on TV and effectively giving the whole world a copy is what he wants to do with it. But for others, there is the monitor that the court put on the sidewall, so that for exhibits the court decides are appropriate to be published in open court, then that's where the monitor is. He didn't specify, and it will be okay for the camera guy to go ahead and watch it on the monitor in open court, but that is ultimately how things fleshed out. Apparently, what we heard from Mr. Grunander, we do have a little bit of a revision of the schedule. So we started, let me pull up our exhibit list. It's been tweaked a little bit. The witnesses and the exhibits. Originally, we had these six identified. And so Officer Bagley, we heard from today. Agent Hull, we heard from today. Agent Bricker Mortensen from SBI. I think these are 2 people from SBI. They have been taken off. Apparently, state is no longer intending to call them for this. Agent Davis is going to be called. Lance Twiggs isn't really being called. He's just 1102. So I'm not really sure why they identified him as a witness, but maybe just in an abundance of caution for the defense. And then I don't want to try to say this, Faumuina. It's probably terrible. Another SBI. So down to 4 from 6. And they anticipate between 40 and 50 exhibits. Now, their exhibit list is 34, okay, with, yes, granted, some little sub pieces. But we also did see over the course of the day, there's been some tweaking to this as well. So, like, for example, we heard about 12.1, 12.2, 12.3. I suspect this relates to the discovery update, which I'll get to shortly. So I will hold off on that until we get there. Last thing, court is very aware at this point of the whole courtroom setup and the configuration and the risks. The fact that you can see the monitors on counsel table from the location where the camera is located, that means you need to beware. Seat yourselves accordingly if you want to block the view. Otherwise, the camera is going to be able to see it. So court is very aware of that. Mr. Grunander did specifically ask to provide the discovery update from Mr. McBride. Not entirely sure why, because there's ultimately no real update. What he said was, as of June 18th, 100% of what they have received has been provided to the defense. So they are back caught up with their flow is things get submitted to SBI. SBI processes it, enters it into their evidence system, whatever case management program that they're using, then provides that to the prosecution. The prosecution reviews it for redactions and things like that, and then hands it over to the defense. So at this point, everything SBI provided to the prosecution has been given to the defense. With an exception, he said they did receive additional materials from SBI in preparation for this hearing that have not been provided yet. That's where I think we go back to this 12.1, 12.2, 12.3, those types of things, because some of those were the 1102 statements, the statements of the people who, like, you know, C. Noble, I think, that was originally 13. Maybe that got renumbered or something like that. But they've just basically subcategorized some of this. And so I suspect that where we are seeing exhibit numbers show up in court that aren't reflected on this particular filing, that's why. It's kind of the late last minute stuff that either they just got, or they compiled it and prepared it. They like changed their minds about how they want to present this, specific thing. So they've got a different copy. That's what I suspect it's about. The defense had nothing to add by way of elaboration. So nothing on the record vis-a-vis an objection. It remains possibly the most friendly, cooperative discovery process I've seen in years. Trying to think of like the last time I saw a discovery process. 10 months in, hundreds of terabytes of data handed over, not a single motion to compel. I don't know, guys, it's been a while. We were like 4 deep in Koberger by this point. So we started, of course, with Chris Bagley, Officer Chris Bagley, the former UVU police officer who is now with the Spanish Fork PD. Couldn't help but notice there's been a lot of movement. He's moved to a new law enforcement position. Agent Hull has moved to a new law enforcement position. It's not uncommon for there to be lots of lateral movement in law enforcement jobs. But I am curious about just the timing and the impetus. Does it have anything to do with this case? Don't know. Probably doesn't really matter. But as far as Chris Bagley goes, he made his move about 5 months ago. So 5 months before that was the shooting. 5 months after that, he gets a new job. Means he's looking for a new job sometime in the interim. Don't know, but this is a guy that's moved around a lot. 26 years as a police officer. He's been in a few different departments. Talked about the Post Academy in Utah, a 600-hour academy that he went through to get his certification. On September 10th of 2025, he was employed at UVU and had been for 5 years at that point. They would patrol the campus. They investigate campus crimes. He compared it to being like a school resource officer, which is like, school resource officer to me is always going to be the cop in the elementary school. You know, it's just my association. I know it's not only the elementary school, but that's just what I think of. And so, the infantilizing of the college student class. It's like all I could kind of get out of this. Oh, you have a school resource officer at the university now. But no, it's like community oriented policing. So spending time on campus, being visible, trying to be a resource and a problem solver, stuff like that. The kinds of things that police officers do to try to build relationships to help them prevent crime before it happens. Before UVU, he'd been at the Utah County Sheriff's Office. He'd been at another police department. He had been at the Salt Lake County Sheriff's Office. He's done K-9, he's done SWAT, he's done motorists, he's been a field training officer, he's been a detective. He's really run the gamut of the law enforcement experience. And through his position at UVU, he had access to the video surveillance system. It was a daily routine for them to watch the video, check the video, use the video system. You would be able to track people's movements. You could make maps from it. A whole variety of different things that they did with that system. Also became familiar with the campus and the surrounding neighborhoods. So we got a lot of visual description of these neighborhoods, but I found it a little bit challenging to follow. This is like, before we were really sure, I guess, that we could show the published exhibits on TV. And so everybody is looking at the map in the courtroom, but the photos, the aerial photos, but we can't see them. And so it's a little bit hard to catch all of these descriptions. But basically, the point is that the campus butts up on a neighborhood. And so there can be overlap with traffic. It's a point of entry and exit for people who were like coming onto campus to steal bikes and things like that. And they would also do backup for the Orem Police Department. Very familiar with the campus, the outdoor area. So I went ahead. You guys, many of you, I'm sure, have already done this. Many times. But since I couldn't see the aerials, I'm like, okay, well, I gotta go look. Google helped me out here. So this helped me get oriented a little bit. I'm gonna zoom it in. It's this massive zoom in kind of out of nowhere. But this, I don't know if you can see. Can you see when I use my, I can't tell if you can see when I use my pointer, my little mouse to point things out over here. Give me just a sec. Now it went small. I'll go big. There we go. Don't show all of my searches. Okay, yes, you can see it. So right here where the arrow is, that's the amphitheater. That's what they've been talking about. This is the grassy area with the seating. This is where the tent was. This red here is what he's been referring to as the Hall of Flags. This is not the Sorensen Center. I forget which building is which, but the one that matters most for our purposes is this one right here with the leveled roofs. This is the Low-C Center. So this part in particular over here is going to feature because that's where the line of sight is to right there. UVU Fountain Courtyard, they call it. But so as far as the neighborhood goes, we're talking about this up here, north of College Drive, and he described a horseshoe. This is the horseshoe. This is the horseshoe in the different houses. And this all mattered because this is the neighborhood they went through and canvassed when they were looking for Ring doorbell footage. So this is the area that they're describing. I gotta say, I hate this naming convention. I hate streets getting numbered like this. It's so confusing. West 850th South, West 850th South. So I gotta remember it's West 850th South and not North and not East and not 8. It's like, it's too much to remember. Why don't you just call it like Orem Street or something? You know, University Court. Would that be so difficult? But no, we have this naming convention, so that's my pet peeve. I accept responsibility for that. It's on me, but I do find it a little annoying, and it's gonna be challenging for me to track all that. See, like, all you gotta do is cross the street, and here's a nice cherry drive in a sunny lane. I mean, come on, this is not difficult. Okay, one thing I noticed right off the bat with Orem here. These are big roads. Look at these nice big roads. There is nothing like Mormon towns for the roads, for nice wide boulevard. Okay, it's really a thing, and often tree lined and stuff like that. Lots of room for lots of cars and U-turns and stuff like that. I don't know what it is with the Mormon towns in particular, but they really loved a wide road. It's one of the things. My grandfather was from Logan, Utah, so I've spent some time down there. It was like one of my favorite things about Logan. Like, wow, these roads are so wide and cool. So that is our orientation. He worked through a lot of the buildings, the Hall of Flags that we identified. The Fugal building, I couldn't figure out which that one is. The Woodbury Business Building, couldn't figure out what that one is. I guess it's here on the map. The Woodbury School is. These are just the buildings that are kind of in the immediate area of the courtyard, the amphitheater where this all took place. The Locy Center, of course, is the important one. He also called our attention to the LDS Institute. Let me go ahead and pull it back up now since I got ahead of myself. The reason why I think this is going to matter is because the way he described it, this up here, okay, so get us back reoriented. Here down here is where the amphitheater is. Here's the Locy Center. It's right next to the Locy Center over here. This is the Utah Valley Institute. And so the reason why this matters is because he describes that there's a parking structure that is west of here. So I believe he is talking about this thing right here with the blue P that's marked UVU parking garage. This right here. It has several levels, and there's also a parking lot across the road over here. There's another parking lot across the road over here. I think he was talking about this one because he's saying north across from the parking structure. Maybe even this one right here across Campus Drive. So Campus Drive is the north end of this parking structure. The second level of the parking garage exits to a road, or on the north end of the garage, there are stairs, and then there is a tunnel across to the Institute building, this right here. So there's a tunnel to get from here to here. That's why they're pointing these things out, because we know from the probable cause affidavit that some of their surveillance footage is showing entry into a tunnel and then coming back out the other side of the tunnel. So that is orienting us to the movements and the position of who is where and what's going on. So yeah, we went through exhibits. We stumbled procedurally with the exhibits in elementary ways that are kind of shocking to see in a death penalty trial. Okay, it is elementary that if you are going to show an exhibit in a courtroom to the entire world, it has to be admitted into evidence first. You don't publish something that's not admitted into evidence. You admit it and then you publish it. This is not rocket science. This is so simple. They struggled with this in Karen Reed too. I don't know why this particular one is complicated. But Some of it is logistical challenge, like when the intern walked up, they had one big poster board exhibit, and the intern walks it up and puts it on the lectern, the easel behind the witness, so he can look at it and authenticate it and stuff. But like, it's not in evidence yet. You're not supposed to display it to the whole courtroom. So normally, what you do is you turn it away from the courtroom. You just, like, hold it. Here's here's what you need. Here's what you need to see. If I just put it on the easel, it's going to be like that. No, I'll just turn it. Just turn it. Show it to the witness. Really not that hard. But just for whatever reason, they were struggling with this. So they described a whole variety of different aerial photographs. We got objections to those. So we started with the objection to the foundation for these photographs because the person who took them wasn't here to testify and didn't provide an 1102 statement or anything like that about when they took it, the circumstances and when they took it. And so defense is objecting to lack of foundation for the photographs. The state argues that's not required. You don't have to have the person who took the photo. The only requirement is that the witness has knowledge and can identify that it's accurate or not. So who has the right of this one? Well. Let's go ahead and look it up, shall we? Because, as I'm sure you're not surprised, yep, there's a rule about that. And it's Rule 901 here. Authenticating evidence. This is what they have to do. To satisfy the requirement of authenticating or identifying an item of evidence, the proponent must produce evidence sufficient to support a finding that the item is what the proponent claims it is. That's it. And so what meets that burden? When your evidentiary standard is low, like probable cause, then somebody saying, yeah, I recognize it, is going to be good enough. It might not be enough for a jury who has to decide it beyond a reasonable doubt. And so you might want to bolster your authentication showing when you're in front of a jury. But just for purposes of bare admissibility into court, the bar is extremely low. It's just somebody saying, yeah, that's what it is. And yeah, it looks like that. So when it comes to examples, testimony of a witness with knowledge that it is what it is claimed to be. It is claimed to be an accurate photograph of UVU. Are you familiar with UVU? Yeah, I am. Does this look accurate to you? Yeah, it does. We're done. Okay, we're done. The foundation has been established. There's these other very specific things, but that's the one that we're operating under here. Is just he knows the campus layout, so he can identify, no, this building isn't supposed to be over there. No, this was taken before some remodel happened or something. We can identify things like that for the record. So authentication is a very low bar. Foundation is a very low bar. The fact that this objection was made, it's the first objection that we got from the defense. Really, from the outset, this is previewing. This is revealing the strategy. Oh, they're going to object to everything. Okay, they're going to bring whatever objection they can think of, whether it's good or bad. Okay, because this isn't a good objection. It's not going to win. It's not going to win. There's really not a good argument to make under the law that he didn't authenticate it by saying, yeah, it's an accurate photo of the campus. So the state has the right of that particular argument, and so Judge Graff did overrule it, allowed these exhibits in. This was also the first time Ms. Nestor referred back to the standing objection that they filed. So they kind of sequence of events with this. As we know, they filed a motion arguing that using hearsay evidence, as Utah law allows them to do, is nevertheless a violation of the federal constitution, that there are confrontation rights, due process rights, and things like that under the federal constitution that require in-person testimony at a preliminary hearing. That's their position. It was not particularly well legally supported, but nevertheless, That's the position that they're taking. Doesn't really matter for Judge Graff's purposes, because what Judge Graff cares about is that the Utah Supreme Court already decided this issue and said, no, it's not a federal constitutional problem. It is not in his pay grade to disagree with the Utah Supreme Court about that. So he is always going to follow the binding precedent from the High Court. So he denied that motion. The hearsay is in. So that's one way they preserved it. They then took the additional step of filing a document. Have to remember what day they filed it now. Any of you happen to have the Substack archive up, you're going to catch it quicker than I am. But so I got to scroll all the way down to the bottom. But it was very recently. I want to say it was even like over the holiday weekend that they filed that. Defendant's standing objection to state's exhibits filed July 3rd of 2026. So I can actually pull that one up too. I'll just show you guys what they filed there. Give me a second. Let's get that window. Here it is. Okay. Standing objection to the state's preliminary hearing exhibits. Defendant Tyler James Robinson, by and through undersigned counsel, hereby files these standing objections to the exhibits the state intends to admit at the preliminary hearing, in keeping with his prior filings challenging the use of Utah Constitution Article 1, Section 12, and Utah Rule of Evidence 1102 to deprive him of constitutional rights. It's the same issue that he already did, but he is bringing this. And by the way, noting that additional objections will be made during the hearing regarding specific exhibits, but the following standing objections are made to ensure adequate preservation and in the interest of judicial economy. This is a little bit ironic as the hearing went on, because judicial economy means so that we don't have to keep bringing this up. We want to just have a standing objection so we don't have to keep saying, I object for the same reason, I object for the same reason. And yet, what did they do? They continued objecting for the same reason over and over again anyway. At the end of the day, I'm not entirely sure why this even got filed, I guess, except to just keep making the same point. But, you know, he continues to reiterate these same arguments that these various constitutional provisions are violated. And so he's objecting specifically to the 1102 statements for authenticating exhibits and things like that. Says it limits effective cross-examination and testing the reliability of the evidence. In part, that's because the Utah rules kind of presume the evidence is reliable at this stage of the process. A specific objection to the admission of the medical examiner report without the testimony of the medical examiner, because according to them, again, it prevents the court from assessing the reliability of the report and its contents. And because of that, he doesn't get to, he's being deprived of important constitutional rights. And then the use of hearsay under the 1102 for non-testifying peace officers. This is one of the exceptions under the rule. And so they're going to be allowed to do it. The defense is going to object to it anyway. And then lastly, to allow the admission of written or recorded statements from witnesses who will not be testifying, including the one who Mr. Robinson has been prohibited from calling by the court's order. Yes, we know that that's Lance Twiggs. So he just, you know, makes this writing to document, in case it wasn't clear before, which it was, we still have these specific objections, doing this for a judicial economy, Judge, but didn't end up being all that economical because they kind of ignored their own standing objection and just kept reiterating it over and over again. I do understand why they did that. They want to be very cautious that they don't waive anything, and these can be procedural pitfalls. Did you object specifically enough? Was it clear enough what the basis of your objection was? Because if you didn't say, I object to it on confrontation grounds. You only say I object to it on due process grounds. And when you go up on appeal, you're probably not going to be able to argue violates the confrontation problem. You got to be specific with the objections. So they're just going every which way they can to document ad nauseum, repetitively if necessary, to make sure that that nothing is inadvertently waived. So that was the first appearance of the standing objection. That's what she was referring to repeatedly throughout the day. So after the background that we got about the location, the orientation of what's where and all of that, we then turned to the day of September the 5th of 2025. He was working that day. His shift started at 11 o'clock. So I don't know what the timeline of this event was. I'm assuming the event started at noon. But I don't really know. Didn't really get information about that. Probably will at trial, but it just struck me as it's just I don't know. Seems like short. It just seems like a short time to be showing up for event security an hour before it's going to start. Because surely, yes, all of the setup and stuff like that matters, and a lot of people who want to like sneak into an area, a closed area, you know, it just seems like an hour ahead of time is not really that long. Like people sometimes show many hours ahead of time, like hide out and stuff like that. I don't know. It just caught my attention. There at 11 o'clock when his shift started. His assignment was to secure the top of the Hall of Flags on the south end of the orientation. So he was walking in that area. We paused for an objection from Kathy Nestor to point out that the monitor that was on the lectern was visible to the camera. So yes, we were able to temporarily like squint real hard and see that there's an exhibit on the screen, but somebody is screenshotting it, capturing it, blowing it up, you know, and doing all that. So they turned off the monitor at the lectern so that wouldn't happen anymore. We got some more photos of the location, more objections for the same reasons, same arguments, overruled. They're all admitted. We now identified the Low-C Center. What happens is the photograph is admitted into evidence, and so he then has the prosecutor has the witness point out on the map what some of these things are. But he's not making a good record of it. He's saying this building right here is this, and then you follow this walkway and you get to this building over here, and that's this other thing. Over here does not translate well on a record. Nobody that's reading a transcript has any idea what you were pointing at when you were making these indications. So it was not very good. Judge Graff did us all a solid and pointed that out. This is not making a very good record. There need to be more detail in describing this. So from there, they started describing things a little bit more with their words. The issue with the Low-C Center is mainly the access to it. The roof is gravel. There's a stairway that goes up. It is open to the public. It's got a little guardrail on it, but somebody can jump over it to get onto the roof. You're not supposed to, but people can, or at least could, and obviously did. So the third time we got a photograph, and this objection from Kathy Nestor. We don't know when the photograph was taken or by whom it was taken and stuff like that. So there's no foundation. It's already been ruled against her on just the flat rules of evidence 901. But let me get us out of here real quick. But then we got case law. We got some case law from Mr. Grunander. He was ready here with State versus Purcell. State versus Purcell. He gave us a citation and everything. I'm like, okay, I gotta go look. So let's look at this case. Let's take a look at this case. 1985, Supreme Court of Utah. Defendant Selmar Purcell appeals from a jury verdict convicting him of theft for stealing furniture from an apartment he rented, a second-degree felony. Purcell alleges that photographs of the stolen furniture were erroneously admitted into evidence without adequate foundation, and that the evidence was insufficient to establish either that the furniture was worth more than $1,000 or that he exercised control over it. We affirm the jury's conviction. So basic facts, he rented this furnished apartment after he moved. Some of it was gone. During a lawful search of his new residence, guy's on probation. That's almost certainly what this means. It could be a warrant for something unrelated that authorized them to go in. But what I'm hearing is this guy's on probation, and so they went and checked his house. A lot of times with probation, you don't have... You have diminished expectations of privacy in things like where you live. The probation officer, it's like a condition of you getting the benefit of probation is that you waive the right to say, no, probation officer, you can't come in pretty much anytime you want, pretty much for any purpose you want. So very common way to lawfully enter the residence of somebody that is under supervision. I don't know if that's the case. It's just how it read to me. So they searched it. They found furniture that matched the description of the missing furniture, although not all of it. They seized it, moved it to a storage area at a motel also owned by the landowner, the homeowner. Testimony established that the following day, a Claymar employee took photographs of the furniture. 2 days later, the furniture was released to Claymar and moved into another apartment. Additional photographs were taken after the furniture was moved out of the storage area. At trial, the pictures were identified by several witnesses as pictures of the property which had been seized from Purcell. So Purcell first asserts that he was unfairly prejudiced by the admission of the photographs because the photographs lacked adequate foundation. Here we are. This is spot on. This is exactly what Kathy Nestor is alleging. He alleges that there were fatal inconsistencies in the testimony as to where, when, and by whom the photographs were taken. Exactly what she's saying. This argument is without merit. Okay, it was without merit in 1985 when the Supreme Court put it in writing that it's without merit. But here we are 41 years later raising this objection. Is it a little frivolous? Yeah, it is. Guys, this is a frivolous objection. The defense gets away with it because the defense is expected to push the boundaries because they're defending their client. So they're expected to be arguing things like, well, maybe this is what the law is, but it shouldn't be for X, Y, and Z reasons. Or that's not applicable because of this extremely minor factual difference between that case and my case. Therefore, it doesn't apply. Defense needs room to be able to do that because that's how the law evolves. And that is how you make sure that people's rights are being protected. You want them to err on the side of being overprotective rather than not objecting, at all or enough, and then your client gets railroaded when they shouldn't. So we expect the defense to err on the side of over-objecting, but even by that standard, honestly, this is a frivolous one. It was without merit in 1985. We will not reverse a trial court's ruling regarding the admissibility of evidence absent a showing that the error affects a defendant's substantial rights. In this case, there is no showing that the trial court admitted the photographs without adequate foundation. Under Rule 901(b)(1) of the Utah Rules of Evidence, foundation may be laid to authenticate evidence by testimony which establishes that the evidence is what the proponent claims it to be. In general, if a competent witness with personal knowledge of the facts represented by a photograph testifies that the photograph accurately reflects those facts, it's admissible. That's all they care about. Do you know what the UVU campus looks like? Yes. Does it look like this photograph? Yes, we're done. We're done. The photograph is coming into evidence. Any other objections to it? The perspective is wrong. There's distortion. There's image distortion because of the focal length of the lens. These can be like valid issues, but they go to the weight of that evidence. They don't go to an argument that it should not be admitted at all. Here, several competent witnesses unequivocally testified that the photographs depicted furniture belonging to Claymore and seized from the defendant, and that they were taken after the seizure. Any minor discrepancies in the testimony went only to the details of the time and place the pictures were taken. These discrepancies were explained by the witnesses. Moreover, since they were not material to the purpose for which the evidence was introduced, they did not undermine the adequacy of the foundation. That's it. Okay, a whole Supreme Court decision to basically put that in writing. Often what happens is there's like a practice, or like somebody gets an idea, about here's an objection, here's something that might work. And then you kind of spam it, it gets out into the universe. It gets out into like the defense world, the practice groups and things like that, and the brief banks that people share and all that type of thing. And then everybody starts raising it. And the court thinks it's stupid, right? The court thinks it's stupid. They deny it all the time. But until there is something authoritative published from a higher court that says it, you can't tell them, I've ruled against this a million times. I'm going to rule against it again. It's frivolous. Stop doing it. You gotta get that published so that it's now a matter of legal record, that everybody is on notice. This argument is without merit. And then the court can say, you shouldn't be raising this objection to me anymore. Okay. This was frivolous back in 1985. Now, Judge Graff has the absolute patience of a saint. Okay. This man, like, made for this job temperamentally. My read so far. I'm sure he's lost his temper at some point in his life, but I can't imagine it. I really can't. I can't picture Judge Graff as a baby, as a toddler having a tantrum. Can you even? No. I'll bet he was like the chillest baby. So Judge Graff is not going to smack Kathy Nestor and be like, hey, this objection lacked merit 41 years ago in a published opinion. You are charged with knowledge of the law. Why are you bringing this frivolous objection to me? He's not going to do that. I might. If it was me, I might. We're going to cut this one right off. You're free to object, but you need to have a basis. Otherwise, you are just being obstructionist and you're just wasting people's time. It's not helpful. And it's not helpful to Tyler either. This is the problem. If you're going to spam the court with bullshit objections, you're going to run the risk that when you have a good one, the court's not even going to notice. He's just going to hear you say object and he's instantly going to think, oh, it's more bullshit. And so you've lost your ability to get his attention with the objection. It's a real risk. But it's a strategy call. This is their strategy. I understand the reason behind it. There's always trade-offs. They've decided they need to make their record, even on stuff that is probably sanctionable in a less forgiving court. So that was Purcell. Judge paused to read that, like, yep, that's pretty much squarely on point. We will overrule these foundation objections. Next time, okay, now we have the big poster board version that was displayed. The intern, I don't know if it's an intern. I'm just calling it the intern. Because I don't know, that's funny to me, because it would be. It's something the intern would get tasked with and then yelled at for doing it wrong. You took it up and you showed, don't you know it needs to be admitted before you can publish it? Well, no, even apparently the senior attorneys here didn't know that, at least weren't doing it. So they had to go through the song and dance of Mr. Grunander, then walking up to the stand to turn it back around the wrong way. Anyway, just another aerial photo with some more building locations, different orientation. And we got the same objections from Ms. Nestor, and then we got a new case from Mr. Grunander. State versus Wager. I'm assuming this is Wager. It looks like Wager. Who knows? I might be mispronouncing it. So what's Wager? Wager was convicted of possession of methamphetamine and marijuana. The principal issue on appeal concerns the authentication at trial of a photograph obtained from Wager's ex-girlfriend. The photograph appears to show Wager sitting in his bathroom smoking a meth pipe. Oh, you don't say. Uncontroverted trial testimony established that the person in the photograph was Wager and that the bathroom in the photograph was his bathroom. The trial court admitted the photograph. We affirm. Oh boy. So let's get a real feel for this one. Background. Wager testified during cross-examination that no one had used drugs at his residence. Oh, no shit. You mean he denied it? No way. No way. Somebody super guilty went to try. There's a photograph of him committing the crime, and he goes to trial and testifies, no, it didn't happen. I'll bet he might have had an It's Impossible defense. You guys know how I love the It's Impossible defense. See, he has a disability, a lung disability, and it makes it impossible for him to suck on a pipe. He can't even breathe in that hard. It's literally impossible. This is the kind of shit that you get in criminal trials all the time. Please tell me this guy had some reason why it's impossible that he was smoking a meth pipe in the bathroom. Swore during his cross no one had used drugs at his residence. In rebuttal, the prosecution offered a photograph taken by an informant. Oh, his ex-girlfriend. His ex-girlfriend snitched him out. That is cold, and he didn't see it coming either. That's why he lied in his cross. He didn't see it coming. Photograph taken by his ex-girlfriend informant showing Wager sitting in a bathroom holding in one hand what appears to be a meth pipe to his mouth and in the other a small torch. These are fairly identifiable things. Once you've seen a meth pipe, you've probably seen every meth pipe. Wager objected to the admission of the photograph and argued that it lacked sufficient authentication in violation of Rule 901 of the Utah Rules of Evidence. Specifically, he argued that the state did not have a witness with personal knowledge of the contents of the photographs. So because they didn't have the informant, I'm assuming, testify, yeah, that was Wager sitting in the bathroom smoking a meth pipe, that you can't bring in the photograph based on people knowing what Wager looks like, people knowing what meth pipes look like, knowing what you use to smoke meth, knowing what his bathroom is. Can you build the knowledge, or do you have to have somebody that collectively knows all of it? The state proffered the testimony of a police detective who had taken a photograph of Wager's bathroom during his search of Wager's residence and would testify that the informant's photograph accurately depicted Wager in that bathroom. Wager argued that although the detective could accurately identify the bathroom, he could not testify to the activity depicted in the photograph. It only looks like a meth pipe. What if it's my asthma medication? Okay, it requires me to administer it in this fashion with a torch. This is a medical device torch that I was prescribed for this purpose. I'm just telling you guys, you've spent enough time in criminal defense. You've heard literally every story. The trial court overruled the objection and admitted the photograph. He was convicted of possession of methamphetamine, enhanced to a second-degree felony, and possession of marijuana. Sentenced to 1 to 15 years for the methamphetamine possession. Good Lord. I don't blame him for appealing. That seems nuts to me, to get up to 15 years for simple drug possession. To me, that's wild. Not really seeing that as proportionate. There are people that, like, get drunk and drive their vehicles and hit somebody and kill them that spend less than 15 years in prison. So just in terms of kind of the proportionality of this, 1 to 15 is wild to me. So the issues on appeal. First, Wager contends that the trial court erred by admitting without authentication a prejudicial photograph purported to be Wager using drugs, and then his variety of other ones. We're going to focus on this one. Authentication. Wager contends that the trial court erred by admitting without authentication a prejudicial photograph purported to be Wager using drugs. This court grants a trial court broad discretion to admit or exclude evidence and will disturb its ruling only for abuse of discretion. It's very hard to win an appeal based on the trial judge let in this evidence that they shouldn't have. Very, very difficult to win that appeal because the standard of review is not favorable. This is not the Court of Appeals or the Supreme Court looking at the facts and going, well, that's not how I'd rule. They are looking at this and saying, is this so completely outside the bounds of what the rules allow that I can't really conceive of any reasonable judge thinking this is okay? That's really what the abuse of discretion standard is. Very, very tough to win. To satisfy the requirement of authenticating or identifying an item of evidence, the proponent must produce evidence sufficient to support a finding that the item is what the proponent claims it is. That's the rule. We read it. Such evidence may include testimony of a witness with knowledge. That's also the one that we relied on. If a competent witness with personal knowledge of the facts represented by a photograph testifies that the photograph accurately reflects those facts, it is admissible. And they cite Purcell. Look at that. Kind of thinking about how this all happened and the timeline of how this happened. I'm guessing that intern was busy, that after the first objection, somebody got in the intern's ear and was like, get on Westlaw and find a freaking case that says this, okay? Because we know that's what the law is. So she got on Westlaw, she found Purcell, and so gives that to Mr. Grunander. Mr. Grunander gives Purcell to the court. She then shepherdizes Purcell. Shepherdizing is the process of looking at the subsequent history of a case to make sure that it's still good law. It hasn't been overruled by a later case or something like that. And so through the process of shepherdizing, you see what other cases have cited your case and what they've said about it. So she found this other case that cited Purcell. That's how I'm guessing she found her way to Wager. I don't know, but like I said, this is just kind of how I see it. Obviously, it was the intern. Okay. The intern is going to take all this shit, but actually like carried all the weight. Proper authentication does not require conclusive proof, but instead requires only that the trial court determine that there is evidence sufficient to support a finding of the fulfillment of a condition of fact. That's quite a sentence, isn't it? What? Evidence is sufficient to support a finding of the fulfillment of a condition of fact. If this, then that. If that's Wager's bathroom, then the photograph is accurate, just for example. Thus, the trial court performs a screening function. If the evidence is admitted, then it falls to the jury to determine whether the evidence is, in fact, authentic. That's going to what I was saying before. When you're in a jury trial setting, you might bolster up some of this because you got to persuade a jury, not just that it's admissible, but also that it's good evidence and it's reliable and you should give it weight. And if they got questions about, well, I don't even know if this thing has been, AI generated or something, then you're not really doing your job of eliminating reasonable doubt for those jurors when they consider your evidence. So separate rules there for the court. Court is just the bar. Does it clear the bar? Somebody is saying it's a photograph. Great. Then the parties can present their own cases to argue about whether it's a good photograph, whether it's an accurate photograph, whether it's been altered, etc. But at the end of the day, the bar for the court's part is very, very low. In State v. Bloomfield, this court stated that the general rule in Utah is that when a competent witness with personal knowledge of the facts represented by a photograph testifies that the photograph accurately reflects those facts, it is admissible. Look at that, quoting Purcell again. A surveillance camera recorded Bloomfield robbing a restaurant. Oh, I bet it was impossible for him to have done that. He could not have done that because he was totally babysitting for his girlfriend and he couldn't leave the kids. It's like impossible, guys. At trial, a detective testified that he had obtained the videotape from the restaurant employees the night of the robbery and that it accurately depicted the interior of the restaurant that night. He also identified Bloomfield in the video. His testimony of the restaurant's interior was substantially corroborated by an eyewitness of the robbery. On appeal, this court held that although the detective lacked personal knowledge as to the actual events as they occurred, he knew the videotape had been given to him the night of the incident and that the interior of the restaurant shown on the video matched his knowledge of it. The detective's knowledge sufficiently supported a finding that the matter in question was what the proponent claimed. They're claiming this is surveillance footage from inside the restaurant on this night in question. He's saying that's the restaurant on the night in question. You're done. You're done. In addition, we had the eyewitness corroborating the activity depicted on the tape. The case before us presents similar facts, though without the corroboration. The detective had not witnessed the event depicted in the photograph, but knew that the photograph had been given to him by an informant and that it depicted Wager and his bathroom. No trial witness saw the event depicted in the photograph, but we conclude that additional eyewitness testimony is not necessary for proper authentication. The Washington Court of Appeals, oh God, don't do this to me. Don't bring up SAP. Don't bring up SAP. Oh, good Lord. The Washington Court of Appeals, persuasive authority over here, has held that photographs were adequately authenticated when a witness identified the individuals in the photographs, their approximate ages, and the location depicted. Yep. I kind of vaguely remember this case. Thus, Washington does not require photographs and other recordings to be authenticated by a witness present for their creation. Our Supreme Court tacitly followed the same rule in affirming the admission of photographs of stolen property based on testimony that the photographs depicted furniture belonging to the victim and seized from the defendant, and they were taken after the seizure. That, of course, is Purcell that we just read. Here, the detective was not the photographer and did not witness the events depicted in the photograph, but he had talked to Wager in person, searched Wager's residence, and taken his own photograph of Wager's bathroom. Thus, the trial court could reasonably conclude that he possessed sufficient personal knowledge to testify that the informant's photograph fairly and correctly depicted Wager and his bathroom. Based on this testimony, a reasonable juror could find the photograph authentic based on the comparison evidence, i.e., the detective's own photograph, and the circumstantial evidence, which included the detective's uncontroverted testimony. The trial court properly fulfilled its screening function and acted within its discretion in ruling that the photograph met the standard for authentication. If every single thing in a photograph or a video or something had to be witnessed for it to be admissible, there's no point in having surveillance footage. It's like the whole point is that it's there to capture on camera when people aren't there to see. If you have an eyewitness, you can call the eyewitness. But a camera sure is helpful. Camera has certain advantages over the recollections of an eyewitness. So this to me is just logical. Okay, if you know it's the guy and you know it's the bathroom, whether he's smoking meth or not, whether that's what it shows, that is circumstantial. That is an inference that you can draw from what the image shows. Might be an issue with time. If they were bringing up this exhibit, the state was bringing in this exhibit in their own case in chief to prove he committed this crime on this date that is depicted in this photograph where he's smoking the meth in his bathroom, then I think you have more of a problem, because I can't infer the date the photograph was taken just from this record. Right? I don't know if they took this 10 years ago, 20 years ago, yesterday. No idea when it was taken. If when it was taken was material, that could be a big problem. But it wasn't offered for that. It wasn't offered to prove he was guilty of possessing methamphetamine in the photo. It was offered to impeach his claim that nobody had ever smoked drugs in his house before. And there he is, the guy with personal knowledge of previously smoking drugs in his house. So it doesn't matter when, as long as it's the house, as long as a reasonable inference can be drawn. Yeah, this is you smoking drugs in your house. Then it's going to come in, and it's up to the defense if they want to challenge the weight of that, to come up with some really good explanation. What you're doing there with that crack pipe and that torch that isn't actually smoking crack. So it looks like, yeah, they had a case in the pocket, the Purcell case in the pocket for just the general photographs. The wager seems to be tailored far more to the video evidence, and perhaps anticipating defense is going to object to that too. So might as well get that one in front of the judge. Isn't really, Purcell is fine for purposes of this exhibit, which was just another still aerial photograph. But nevertheless, now the judge has read it. Now it's going to be in his mind. And he's like, oh yeah, there was that case about the video, when this comes up in the video context. So then we walk through all of these streets. I am assuming the reason we heard about all of these streets is not just to tell us there are streets there, but because there was actually evidence obtained from them. We heard about one Ring doorbell camera this afternoon, but that was just one. We heard about 800 South, 850 South, 600 West, 720 West, 925 South. Some of these form the horseshoe. Why any of this matters, not entirely clear yet, but we do know that that one Ring camera was obtained from somewhere in here. So when we get to that, we'll see where that was. So now we go back to the September 10th of 2025, and what he was doing during that shift. So he had to secure the south end of the Hall of Flags walkway. He was on special duty. This was a special event for a guest speaker that he was aware of. He was aware that Charlie Kirk was coming to speak. He saw Charlie when he arrived on campus, because Charlie's vehicle pulled up just behind the Hall of Flags. Underneath it, there's like an opening that the car can drive through. So it sounds like they did that. Saw him do a meet and greet and get some photos taken. And then they went to the tent, the quickie up thing there, answered some questions and talked to people. So at 12:20 is when things started to happen. He had heard someone talking to Charlie, and he glanced over the edge of the railing from where he was standing. He's above, remember, he's in the hall. He's above the tent. And so from where he is standing, he can see just the right side of Charlie's body, but he heard the shot fired, saw Charlie go to the left, and at that point could no longer see his right side. This is happening at 12:23. Everybody starts to get up and run. It's chaos. I can't even imagine. I can't even imagine what it was like in that crowd. I mean, yes, horror everywhere. He thought there were several thousand people that were present. They were on the grass. They were over in the Sorensen and the Woodbury buildings. A lot of people in attendance at this event. And what he heard, the sound that he heard specifically, he identifies, it was a gunshot. I heard a gunshot, and the sound was simultaneous to seeing Charlie falling in the direction to the left. People screamed, ran in all directions. He recognized it as gunfire. So at this point, he ran down the stairs. This was difficult. People were running up. People were lying down, like taking cover on the stairs. I bet this was a nightmare. But he makes it down. He's informed on the radio that they had the shooter in custody, and he was like, "Oh, that's fast. That's fast." And so since he gets this radio message, he's like, "Oh, okay. Well, the threat is gone." I don't know that this is a good inference. You didn't know it was a single shooter. You know there is one shot taken, but you don't know that it's only one shooter. Therefore, you have somebody in custody. Therefore, it's secure. I don't like that conclusion, but that was his thought process. Okay, the threat's gone, so I can start looking to see if there are people that are injured that need help. He said he did see one kid on the ground next to a wheelchair who was convulsing. And this individual said that he was having a seizure. That's horrifying. But no other injuries that he saw. So then he decided to start preserving the scene, containing the area, getting people out of the grass, pushing people out of the courtyard so that they won't disturb the scene. While he's doing that, he looks down and he sees the empty pistol holder sitting on the grass, a holster. And he describes the location of this holster a little bit later. It's at the high end of the amphitheater in the grass area. But he says that it was when he saw the pistol holster that he kind of realized, he's like kind of like waking up or something, that he realized the sound that he heard was more like a rifle shot than like a handgun. More of a rifle shot than like a handgun. And he described the difference. If it's a short bang pop, that's a handgun. Okay, a short bang pop. But if there's a more longer, violent crack sound, that's a rifle. That was how he described it. Not the best use of words. The man is not literary. That's okay. That's fine. I saw in the comments to the live video, somebody left an extremely good description of why the sound is different and how it's different between a handgun and a rifle. And the main reason is because the speed of rifle bullets is supersonic. And so you have a combination of, you have the, explosive, percussive sound of the, gunfire igniting from the spark, boom, propelling the bullet. But then you also have the bullet reaching the sound barrier, basically. So you get like a double kind of sound. The handgun, slower speed, subsonic, so you don't get that second. All you get is just the percussion of the ignition of the powder. I thought that was very, very well explained. Makes a lot of sense. He also identified the sound as coming from the east of him, where he was on the roof of the Hall of Flags. So he says that the chief was there with him. They I guess both see this pistol holster. So the chief is there, and he says to the chief, that was a rifle shot. And according to him, the chief agrees. So they both of them agree, yeah, what we heard was a rifle shot, not a handgun. So then when he realizes, he puts two and two together, it was a rifle, that's when he decides to go to the Low C Center, because he sees, oh, it's got a view, it's got a line of sight. So he decides to go check it out. Went up to the top of the stairs on the south side. And as he got to the top, he saw an object sitting in the gravel that appeared to look out of place. It was on the opposite side of the guardrail, and it was a red and black screwdriver. He did not touch it, but there is a photograph of it. Objections were made. They were overruled. And the photograph of the screwdriver was admitted into evidence. But it wasn't published, so we didn't get to see it. But I don't know, maybe we'll get to see more. Maybe there will be some repeat. Maybe the judge will allow some of these just less graphic things to be released to the public. I mean, Judge, I gotta say, I don't really care so much about the screwdriver, but this sniper pad, the marks, I'm really gonna want to see this. Okay, I'm gonna want to see this. Is this bullshit? Is this not bullshit? I just want to see what a sniper pad in gravel with elbow marks and stuff looks like. I just want to see it. I might have to wait till trial. That's okay. We took our morning break at this point, and when we came back, Judge Graff started by acknowledging he had previously made a accommodation for the victim representative. Everybody else in the courtroom, if you leave while court's in session, you're not going to be allowed back in. Erica's different, guys. Erica's different. She's got way more rights than any of us do. So they're going to accommodate her, not make her have to sit in the courtroom to see stuff she doesn't want to see in order to be present for the stuff she does want to see. If she leaves, she can come back whenever she wants. He then also, we got into this conversation about stuff being published to the gallery because Kathy and Esther like snitched on the on the camera guy. He's publishing the publication. It's been electronically captured by the media. And so the judge now calls for, be clear about what you're objecting to. We got 3 things that are going on. Are we admitting the exhibit at all? Are we publishing it to the gallery? Are we allowing the cameras to capture it? So you need to be very specific about your positions on all 3. As it turns out, it kind of seems like if he's publishing it to the gallery, then he's going to let the cameras capture it. If he doesn't want it on TV, he's just not going to have it published to the gallery. Kind of seems to be how things are going. And frankly, that's the right call to me. Like, there's no reason why the camera shouldn't be able to view anything that people sitting in the courtroom can view. The camera is meant to be our substitute eyes. So I think that's the right way to handle it. But it had just been a little bit murky up to this point. So, yeah. He describes this photograph of the screwdriver as being the top of the Losi building. It's about 10 to 15 feet in from the stairway, and it's by a yellow evidence tag number 5. So we then get an exhibit that is published, but Cameron didn't get it at this point. So this is the photo of the top of the Losi Center with the screwdriver, and he describes it as showing the mountains and Utah Lake up at the top, and then ponds, and then there's Hall of Flags and the white tent, and there's a disturbance in the gravel around a yellow marker. But he says this isn't a very good photo. It really doesn't show the impression that he saw. So instead we get exhibit 4, which is the night view of the same location. And the night view, probably because of the higher contrast with the light, the artificial light and the shadow, brings it out better. Midday, I mean, if this is like a midday-ish photograph, then you're going to have very, flat overhead midday light. It's not going to capture shadows and depressions and things like that. So it does make a little bit of sense to me just from a kind of photography technique standpoint. The night photo would be better here. But also, once again, we have this idea that photos and videos are like perfect. They're super accurate. They're just these little mirrors of reality, and really underappreciate how much wiggle room there is. I mean, with videos, it's obvious. Clipping things out of context is really obvious. It can entirely change the meaning of a video, a little clip versus the entire source. But people don't, I think, always really appreciate with photography how misleading it can be. It can be very, very misleading. There's all kinds of great visuals online. I don't have one ready to share, or I would, but they show you what different focal lengths, for example, different focal lengths, this is the length of the lens that you're using on the camera, what that does to your perspective, because it expands and shrinks space. It can produce, really, just depending on what's being shown, the choice of lens, the choice of length of lens that you use, am I zoomed up, am I wide angle back, can have really dramatic effects on proportion and perspective and all kinds of different things. You have that just kind of foundational issue with photography, but now you also have this added, we're doing it at night, like kind of on purpose to emphasize shadows and stuff like that. I don't know. I would like to see these for myself. I really would, because it just does seem possible for a photograph under these circumstances to, it's an accurate photograph. It's not like they didn't AI generate it. They didn't fake it. They didn't do anything, unusual with it. It's just a photograph. But the way the photograph was set up was done in a way to, highlight this, minimize that, create a certain impression, certain perspective. It just can be a little bit sticky. So this particular photo, he says Melissa Richards, the lead forensic crime scene CSI. She's like the CSI lead for Utah. He knows she took the photo because he talked to her. Hearsay. It came in that one. Well, she did object to that one, but Mr. Grunander argued that hearsay is okay for the authenticity of an exhibit. And yes, he's right, because here we are at Rule 1102. Rule 1102, there it is right there, subsection 3, evidence establishing the foundation for or the authenticity of any exhibit. They can do that by hearsay, reliable hearsay in Utah. So that was his exception. He went a little further because he says that under another rule, 1101, questions of fact that have to be determined in order to decide if evidence is admissible or not, that those get decided by the court. And according to him, that the rules of evidence don't apply to those types of questions. So the judge doesn't have to rely on the rules of evidence to make preliminary factual determinations that will guide him on whether evidence is admissible or not. This is the argument that Mr. Grunander is making. And he's making it because he's previewing the judge. He's letting him know, by the way, even at trial, it's okay for me to do this. It would be okay for me to lay the foundation for an exhibit at trial through hearsay. This is pushing it. This is pushing it. You got different issues at trial because you have very clear and unequivocal confrontation rights at trial. And that applies under Crawford v. Washington, U.S. Supreme Court case, a Scalia decision, by the way. And Scalia gets like a lot of hate in the criminal justice arena, but like Scalia honestly wrote some great opinions for defendants. And reviving the confrontation clause is like being a thing at all is one of the main legacies that I think Scalia has in that department. So anyway, he wrote Crawford v. Washington. And it establishes this category of testimonial hearsay, for which, if you're going to use it at trial, you have to bring the speaker in to testify live. That person has to be available to be confronted. And so what testimonial hearsay is, it's one of these not necessarily real specific categories, but basically if it is the type of statement that would have been made for law enforcement purposes, to investigate, to prosecute, to build a case against somebody, it's testimonial. It's meant to be substitute-ish for evidence, for testimony in that setting. If it's not that, if it's something else, if it's just like, oh, hey, I made a phone call to my friend and we talked about this, and then later all these things happened, and for whatever reason, the content of my phone call needs to come into court. I didn't make that phone call with the purpose of anybody going to jail or, the police identifying anybody as a suspect. It was literally just a phone call. So it would have to meet another hearsay exception to be admissible as evidence. But it's not testimonial, so it doesn't implicate my right to confront that person. So as long as it fits within a hearsay exception, they can introduce that without live testimony. But if it's testimonial, if it's my phone call to the police telling him, yeah, oh, by the way, I remember she said I hit him. I forgot to mention that in like my 4 other interviews I did with you earlier today and like the day before. But like now I wanted to make sure that you knew that she said I hit him. Just kind of like that, hypothetically. That's testimonial. You are telling that to the police for the purpose of prosecuting somebody, for their ability to use it as evidence in a case. So you have to testify to that live in court and be confronted about it. Because of this, I think this is a really sticky position that Mr. Grunander is arguing here, and I'm not really sure that I buy it. I also am not sure that I really buy his premise that this rule applies at all. Normally, when they're talking about things like a question of fact that's a predicate to admitting evidence, they are talking about things like, for example, 404B. Rule 404B is the rule that says your prior bad acts, we don't get to bring those into evidence just to show you're a bad guy, you suck, you did stuff like this before, so you probably did it this time too. It's not admissible for that purpose. But there are a variety of other purposes that are justifiable reasons for prosecutors to introduce that type of evidence. Very common example I'll give you. There's a domestic violence case. Spouse is making accusations against another spouse that there is violence. The accused spouse says, no, I didn't do that, and I would never do anything like that. Testifying spouse is now like, yeah, you did it 50 times before. You did it all these other times. It's not admitted for the purpose of showing he did it this time. It's admitted to impeach his testimony that he's never done it before. Sometimes it'll be a situation like the witness makes a statement to the police, right? Tells the police at the scene what happened. This is so common. Tells the police at the scene what happened. Spouse gets arrested, goes to jail, immediately violates the restraining order, calls the reporting spouse, and they chit-chat. And reporting spouse decides, I'll recant. I'll go to the police. I'll tell them, never mind. It didn't happen. I won't show up. Or if I do show up, because you'll get subpoenaed and you'll get hauled into court, and they'll get a material witness warrant for you, throw you in jail until you agree to testify, even if you don't want to testify against your spouse anymore. Domestic violence is a really difficult situation. Anyway, it will be admitted for that reason, because they'll bring it in to show this is what happens with domestic violence. This is the pattern. This is the pattern of what happens is, it happens, then they recant. All part of the cycle. So things like that are pretty common. Those are the types of predicate facts that normally I think this rule is talking about, because they have to decide things like, prior conviction, for example. We want to bring up this guy's, prior conviction for domestic violence. Well, I have to decide if it happened at all. If somebody is saying, oh, he beat me up before, the judge has to decide, Did that even happen? Is there enough evidence for it to even happen? He has to have a preponderance of the evidence is typically the standard for that. So then if he decides, yes, it happened, then we get to the question of, okay, given that it happened, is it admissible for what purpose? So that's usually what I'm thinking of. I am not thinking of just basic authentication facts. Some of those seem to me like they could be testimonial, and that could be a real problem if the state tried to go down that road and the judge agreed. So Grunander pushing his argument, seeming to kind of trying to want to draw a little line in the sand that, yeah, I'm going to do this at trial too, so be prepared. Well, forewarned is forearmed, because I see that being potentially a problem. He brought up another case. This is the one I did not have a chance to look up, but I did get the citation. So let me find it right here. 384P third. Where's my keyboard? 186. State v. Griffin, Utah Supreme Court. Let's take a look, shall we? Let's see what his other case was. State v. Griffin. This 32-year-old murder case is back before us on appeal for a second time. Oh boy. Oh boy, words nobody ever wants to read. So they retried him. He got tried, he got convicted, he appealed, he won, he got retried, he got convicted again, and now it's back up on appeal. In 2005, Glenn Howard Griffin was charged with the 1984 murder of Bradley Perry, who was working at a Texaco gas station in Perry, Utah. The state sought the death penalty. The jury convicted Mr. Griffin of murder, but imposed a sentence of life without parole instead of death. When the case was first before us on appeal, we remanded it to trial court for a Rule 23B hearing addressing 3 issues regarding Mr. Griffin's claims of ineffective assistance of counsel. We stayed the rest of Mr. Griffin's appeal pending the outcome of these proceedings. We now address the trial court's findings from the Rule 23B hearing and several of Mr. Griffin's original claims, based on which Mr. Griffin seeks to set aside his conviction. We affirm Mr. Griffin's conviction. So he argued on appeal. My attorney was ineffective. They had an evidentiary hearing on that to establish what happened. Very likely, we'll probably see, very likely the defense attorney testified, because when you argue ineffective assistance against your attorney, you are more than likely, generally speaking, you're waiving your privilege as to kind of how all that went down. So it is always a bit of a proceed with caution type of thing with an ineffective assistance of counsel claim. Okay, so there's a lot of info about the crime here that I don't really care. I want to know what the issue was and why he got here. There was an admissibility of evidence issue. Second standard of review applies to the determination that there was a proper foundation and to the determination of the admissibility of expert testimony. So the standard of review for the denial of the motion to dismiss is correctness, which basically means the court is going to look at it independently and decide, did the judge get the legal question right? Because that's something appellate courts are in a position to be able to evaluate. But was it a good idea to admit this evidence? They will be far more deferential to the trial court. So here's all of these standards. Nuclear DNA blood. Mitochondrial DNA hair. Claim of an actual conflict of interest. Okay. Want to see where we get to with something having to do with the admissibility of evidence, maybe a failure to object, something like that. Nuclear blood, challenges to chain of custody, the foundational. Okay, here we go. This must be what we're citing this case for. We also conclude that the foundational evidence for the nuclear DNA blood evidence violated neither the rules of evidence nor Mr. Griffin's Sixth Amendment Confrontation Clause rights. Oh, they read my mind. They read my mind. Confrontation problem here. This could be testimonial. Okay, what do we got? We first address challenges to the chain of custody. I don't think this is going to be the problem. This is just a, is there enough to admit it? And then similar to the authentication requirements, very low bar to establish chain of custody, and then problems with it go to the weight that the jury gives that evidence. So how did they establish the chain of custody? Students received these bills. Foundation for the field notes, the detective's field note. Okay. So detective is now dead. Got 4 $1 bills and a cigarette package from these students. Checked them into evidence as established by his field notes. So all of these things are what they have to rely on, because we can't rely on Detective Beard because he is no longer with us. The requisite foundation for admission of the field notes was laid by Officer Yates. I'm going to assume this is Yates, who testified that the field notes were made by Detective Beard and that the notes have been maintained since 1984 as part of the records of the Box Elder County Sheriff's Office, and by Sheriff Yates, who recognized and authenticated the handwriting on the field notes as that of Detective Beard. They also submitted evidence receipt, property report, a form designed and used to authenticate the nuclear blood DNA evidence and establish an unbroken chain of custody. We have Mr. Pratt testifying that he received the material directly from Detective King in 1984. He signed the evidence receipt and property report. Based on this evidence, the trial court found that the evidence and property report has been maintained since 1984 as a part of the records of the Utah State Crime Lab. This must be what they're getting at. The judge made this preliminary factual finding about the status of the documents to show that they will fall under the business records exception to the hearsay rule. They are business records. To be a business record, you have to make a showing. This is the type of record that is ordinarily kept in the course of business. It's not like a special thing. It's normal. Like you keep receipts, you keep ledgers, stuff like that. You keep client lists, whatever it is. Police reports, very common. Some states make them statutorily not business records for this purpose, but others do not. So factual things that have to be established. It's kept in the ordinary course of business. It's made on or about the time of the events in question. Type of thing that they rely on in business for this purpose. These are facts. And so the judge has to find those facts in order to find if the business exception applies at all. And sometimes there might be disputes. I don't think this is the type of thing that this business would normally create and keep as a record. That could be a dispute. So the judge has to decide. That's what he's talking about vis-a-vis the factual questions. I want to see the issue here with the testimonial hearsay. Okay, the hearsay issue. Whether the trial court's use of Detective Beard's notes to establish a foundation for the admission of the nuclear DNA blood evidence violated the rules of evidence. They rely on this Rule 104A. The court is not bound by evidence rules except those on privilege when it comes to these preliminary questions about admissibility. And this court bought it. Rules of evidence don't apply, so you can't just say hearsay. The notes are hearsay and therefore they don't come in. It's determining a preliminary question, so it could have based its ruling on 104. Even if it didn't, it could have. Here's that. I've brought this up so many times. We may affirm a trial court's ruling on any legal ground or theory apparent in the record. This is why, this right here, guys, this right here is why Judge Bev was like, no basis for the objections. Don't state the basis for the objections. Why? Because if you state it, then that's what I'm ruling on. But if you don't state it, then any possible thing that could affirm me, any possible thing is okay. So just object and let me roll with it. That's what this was about. A very common rule. We see it here. So even if they didn't actually, even if the judge didn't actually say Rule 104 is why I'm making this finding based on the notes, and I don't have to apply the rules of evidence, he could have. So it's good enough. Good enough. But the confrontation clause, this is what I want to see. I'm sorry, I'm kind of like nerding out on this stuff right now, but I do. I'm kind of curious. They say it's non-testimonial. Okay, how is this non-testimonial? Okay, Mr. Griffin claims that use of the notes violated his rights under the confrontation clause of the Sixth Amendment. However, the Sixth Amendment confrontation clause right does not apply to non-testimonial hearsay, such as the notes at issue here. Thus, the notes did not violate Mr. Griffin's Sixth Amendment rights under the confrontation clause. How do you get to non-testimonial? I got to see this. Okay, here's Crawford v. Washington. We talked about all this already. It's not a comprehensive definition of testimonial, but 3 core formulations: ex parte in-court testimony or its functional equivalent, extrajudicial statements contained in formalized materials, and statements that were made under circumstances which would lead an objective witness reasonably to believe that the statement would be available for use at a later trial. The notes of Detective Pierce. So what they did is they took a hyper literal, hyper technical interpretation of these definitions of what is testimonial hearsay and made this wide-eyed ruling. It's not possibly any of those things. They are regular observations. They're not accusatory or matters of judgment, merely notes reflecting the performance of ministerial duties. Would these notes have been available if the guy was alive to rely on to refresh his recollection? My view, if that's the case, they're testimonial. I'm not buying this. Oh, well, anyway, we know now that's how they got around it. It is an issue. If it's potentially testimonial hearsay, it is an issue. They have to bring in the live witness. It would be very, very risky not to. I don't buy this this little workaround that it's not testimonial, but you know, it's, which court was it? No, I don't even remember. Are we in the Supreme Court here? I think we're in the Utah Supreme Court. Yeah, we're in the Utah Supreme Court, so their opinion is far more authoritative than mine as far as what the law in Utah is, but I'm entitled to have some opinions about what it should be. All right, thank you for entertaining that that segue through Griffin. I hope that didn't bore you all to tears. I'm like I said, it's very much a nerd kind of thing for me. Had to go down that rabbit hole. Okay, so he overruled. He also, judge at this point, notes, he's like reminding you guys, I'm aware of your standing objection. I am aware of it. I'm noting it. Yes, it's there. This particular exhibit, judge points out, well, there's other artifacts in this image. There are some other evidence markers. So Grunander goes back to kind of explain what all that is beyond like the first picture that he saw. There's more evidence markers. There's these orange red triangle things, other stuff, but it's all fine because she said to him outside of court, it's fair and accurate. So we're good to go while she's taking the photograph to be used in court. There's a major testimonial problem here, guys. This is not mere ministerial collection of evidence. Like, that's just not how it works. That's not how it works. That is total bullshit from the court. This is testimonial. Anyway, it doesn't matter because we're not at trial. So this exhibit 4 is what shows the disturbance in the gravel that he says it looks like a sniper pad. He describes it as a sniper pad where somebody is lying prone and it shows markings from their elbows, their knees, and their feet. And it's on the southwest side of the Losi Center roof. Another photograph, same kind of deal. Same objections. It gets overruled. It's admitted. So as far as securing the scene, he says he put some crime scene tape around this proned area that was where it was within the line of sight to the tent, and secured entry onto the roof at the guardrail. He basically got a cop to say, stand here and don't let anybody come in unless they are crime scene people, police people. At that point, he left the scene. It was a female county deputy was all that he knew. Doesn't know who it is. A female county deputy told her not to let anyone inside the crime scene who is not a police officer or investigator. We can presume that this female county deputy should have written a report about her role in all of this. Goes to the security and the preservation of the evidence in the chain of custody and so forth. So we can probably find out who the female county deputy is because that's likely to be a trial issue. But for now, it really doesn't matter. But they do probably know who that is. And I kind of appreciate, honestly, when they don't just like fill in the gaps in their memory with what they've learned after the fact, you know, because he might now be, oh yeah, you know, I know who that was now, but he hasn't filled that in. He's like still presenting it. I don't know. It was just some female county deputy. Not my worry, not my monkeys. That's your problem. That's your problem, prosecutors. Chain of custody is your beast. So he said he realized he's talking about this realization that they probably do not have the shooter in custody. Okay, the guy that they grabbed, probably not their shooter. We already know, wait, it was a rifle, not a handgun. Went to the Losi Center, seeing the prone area. Rifle was probably here. This is probably where the shooting happened. This isn't where the guy was that we arrested. We probably don't have the right guy. So he contacted the dispatch at this point to have them look at the security footage from the roof and look for a male on the roof of the Losi Center. So dispatch looks and says, yes, there is. He ran kind of west, southwest towards in the direction of the tent, stood up after the shooting and then ran northeast on the top of the Losi building. So based on that information from dispatch, he knew there was a possible shooter on the run. Ms. Nestor objects at this point to all the hearsay. Just objecting to all the hearsay. Go ahead. It's fine. A little snarky. This one, Mr. Grunander says, we're not offering this bit for the truth. We're just offering it for the effect on the listener as far as like what dispatch is saying they saw on the camera. This is kind of one of these catch-all justifications that prosecutors will try to use all the time to get around the hearsay rule. It's not about the truth of the matter asserted. It's just to understand the progress of the investigation. It's just so you know what the police thought that they were working with, and therefore you understand why they took the actions they did and made the decisions that they did. It's not like inherently wrong or sus. They just, tend to apply it excessively in ways that they shouldn't. But there is kind of a hidden implication in there, isn't it? The cop thought it was right because he relied on it. He thought it was true. I guess the only reason it's not being offered from the truth is because if we're just following the investigation as it happened and talking about what we learned, then the investigation could take me in another direction. I could learn in the course of my investigation that initial information was wrong, and so I did this other thing. She's like, it's totally offered for the truth. No, it's not. Judge is like, it's fine. It's fine. I'm not going to accept it for the truth, but just for the effect that it had on the listener. So he describes that the individual was seen on the camera running north on the rooftop. So based on that, he needed the Losi building secured. He wanted it searched. So he went down to the police department, which happens to be right there. Apparently it is in the Losi Center. Looked at the video himself. It shows the person on the roof dropping off the northeast side. So then he grabbed more crime scene tape and went to the northeast corner to secure that side of the building. And that's when he saw the shoe print in the grass. I have to assume this is just like an indentation. This is not a print in the sense of like, you know, the pattern on the sole of your shoe being visible, but who knows. And also a scuff looking up like towards the roof where someone had dropped down. And those were not normal, so that got his attention. So he put the crime scene tape up around the whole area and then once again released the scene to 2 other officers. Hang out here. Don't let anybody in. As far as the disturbance in the gravel goes, he did not himself walk through it or touch it, he says. So he secured it, handed it over to law enforcement. He did not contaminate that part of the scene. Same thing with the shoe print that was on the northeast end of the building. He didn't walk through it. He didn't disturb it. He just, at this point, went to the Fugal building, which is where the Incident Command Center had been set up. The headquarters for the investigation, basically, and gave them the information. That was all of his direct testimony. That was what we got from Officer Bagley. So then we got cross-exam from Kathy Nestor. That's not our first flavor of Nestor in this case. We got some cross-examination from her in the motion to disqualify the prosecuting attorney's office. She does have a tone, doesn't she? Like, even when it's not bad, even when she's not like really leaning into that obnoxious, snarky tone, it's always kind of like there. And so I feel a little bad for her because I don't think she's trying to do that all the time. It's just kind of how she sounds, but it's really off-putting. I'm sure it's been brought to her attention before. But it is what it is. We get through it. It didn't bother me too much this time, but I can understand the people that Kathy grates on. I do understand why. So as far as we start with his knowledge in advance about the event, she wants to know, what were you prepared for? What were you expecting? What were you told to do? What was the coordination? What was the security plan for this? So he knew it. He did know in advance about the event because he had signed up for overtime. This is not he shows up to his shift and just gets sent over to do this. He signed up for it so he could get his overtime. There was no briefing. They call it a debrief, but debrief is after the fact. What she really meant was there like a pre-meeting where they talked about what the security plan was. Nothing like that, he says. He just checked in. The chief said, "Oh, there's people up on top of the Hall of Flags throwing stuff down onto the tent. So maybe somebody should secure that." Yeah, maybe they should, because what if it was freaking grenades they were throwing on that tent? Good Lord. This security is just madness to me. This is wild. There's already people there throwing stuff down onto the tent. So he went there to secure it. Doesn't know if they actually had a security meeting, but he didn't go to one. UVU itself, the police department employs 15 people. 6 of them were there. 6 of the people were there to patrol. It was basically 5 patrol plus the chief. He did expect that there would be thousands of attendees. This would be a well-attended event. All of the officers are armed. They have Glock pistols. There were no magnetometers. These are the metal detectors, the thing that you walk through. to get into court. Didn't have any of those set up. Nobody is being screened to enter into this area. This is like such a high trust scene. It's just kind of wild, honestly. It's a shame that we just are at an era, at a time in our society where you just can't trust like this. You just can't. I can't believe they didn't have metal detectors screen people coming in. No drones that he knew of. No drones flying for security. UVU doesn't have any, so they weren't in a position to fly any drones for security. Very easy way to just keep an eye on anything suspect and then be able to also rapidly respond to something. If you see something suspicious, just pop the drone over there to put eyes on it for you. It's way faster than somebody on their feet. Not available, didn't use it. When he got to Low C, there was nobody from law enforcement there. There was nobody there, not on the roof, not on the stairs, not on the walkway. Kathy is trying to set up that it could have been tampered with before he got there, in the time frame between the shooting and when he got there and saw it. Maybe somebody walked through it. Maybe somebody else did it. Maybe it's not. Maybe it's not the shooter. This is all valid cross-examination, valid questions. It's not going to do much for them here in this context, but it gives us a little bit of an insight into what they're thinking strategically in handling the defense. Is there an argument to be made that you know, that gap in time creates a reasonable doubt as to whether it was in fact the shooter that created these marks? Well, if the entire area is on surveillance camera, then that can probably be ruled out. But she's working with what she has at this particular hearing. So nobody else was there. As far as the holster and everything, any other guns that she saw, Utah is an open carry state, he says. So this is not a gun-free campus. This is not a gun-free zone. Constitutional open carry is recognized, so may very well have been people openly carrying at this event. Although he did not see anybody who was not a law enforcement armed that day. He was aware that Charlie had his own security. One of his security detail was on the Hall of Flags roof with him. That security officer was armed. There were others in the crowd below and also with Charlie in the tent. He is not aware of any other agency presence for this security part. So it wasn't like they called in the sheriff, they called in the Secret Service, you know, anything like that. UVU is the security. Apparently the 6 of them. 6 of them, Charlie's staff, thousands of people, no metal detectors, already like unfettered access to throw things on the tent just the hour before. The foreshadowing is terrible. Not good. He did not receive any kind of like written briefing materials or notes, so nothing that formal. As far as his response, what he did when he was trying to secure the scene, it was just hectic. He was trying to push people away. He prepared a written report that day or the next day, so she uses it occasionally to refresh his recollection. Yeah, nowadays we have to ask, did you use AI to help you write that? You gotta ask that for everything now. Is AI involved in that? I'm kind of surprised they didn't ask, you know, with any of the photographs and stuff. Do you know if this is AI generated? You know, if AI contributed to that? They didn't ask. Probably could have. So the first shot he heard reiterates 12:23, but in his report he didn't state the direction of it. He didn't put it as in his report that it came from his east or from his right-hand side. And so she had walked him through the classic. This is the classic setup to impeach a law enforcement officer with his report. You went to the academy. You learned how to write a report in the academy, and they taught you why it's important to write reports in the academy, because you're going to need to come into court someday. And so the report, you're not going to have a perfect memory of everything that happened, right? You don't have a perfect memory of everything that happened on September 10th. And so that report is your way to include all the important details to make sure that if you're not in court for maybe a year, maybe 2-3 years, maybe it's 20 years down the road because we had an appeal and we're back for the retrial and you've forgotten everything. That's why you got to include all the important details in your report, right? Right. So then you point to what he didn't include in his report. Implication: either it didn't happen and he's making it up after the fact, or it's not an important detail. You didn't consider it important enough to put in your report. That's the implication. Does it mean he's wrong? Hard to say. Memory is a tricky thing, as we know. A lot of it gets filled in after the fact, and kind of once he knows what the theory is, the working theory of where the shooter was and everything, it's going to be really easy for your memory to adjust to accommodate that new information. Be like, oh, now I know the orientation is over there to the right, so in my memory, I'm going to hear it is over there to the right. It's very possible. I'm not saying that is what happened. I'm just saying that's kind of how memory works. So it's not always all that cut and dry with things like that. It was when he saw the empty holster that he realized there was this line of sight to the Losi Center, and so that's why he decided to go there. It was only one shot that he heard. So he came down from the Hall of Flags ceiling onto the grassy area. This is where he clarifies where he found the empty holster, because it's like, is this near where the guy was taken into custody? No, it's other end. It's further away. It was up in the top area on the grass. It was an empty, concealed holster for a pistol, is how he described it. I think it was one of those little inside the waistband holsters for your appendix carry. It just would make sense to me. It's a very, very common concealed holster. It could be just a little pocket one too. Who knows? He didn't take custody of it. He didn't tell anybody to take custody of it. He just left it there on the grass. Did anybody take it into custody? No idea. No idea. We don't know. That's a little seed being planted. No idea if it was fingerprinted. If it was fingerprinted, that would suggest they took it into custody. Don't know. He was made aware that there were drones in the air at some point, but they were not UVUs because UVU doesn't have them. It was brought in after the shooting to take the images. When he heard on the radio about them having the suspect in custody, that was within about 30 seconds of the shots being announced. So it was within 30 seconds of hearing the shots that was announced over the radio that they had a suspect in custody. So yeah, he was quite surprised. I can imagine. Yeah, that would be very fast. And so that was right near where Charlie was sitting. George then was like right up front. He wasn't near the holster. The holster was up at the top level. The suspect was below. This was the fishing expedition a little bit. She didn't know. Kathy didn't know the answer to these questions. She knew what she wanted the answer to be, but it wasn't the answer that she was getting. And the common wisdom, of course, don't ask the witness a question you don't know the answer to. You don't want to be surprised with the answer. But if you are going to be surprised, I'd much rather be surprised with that answer here at this preliminary hearing than I would at a jury, in front of a jury at a trial. So this is, I think, that using the preliminary hearing as the discovery device, the thing it's not made for, used to be, but isn't anymore. It's not there just for purposes of you kind of fleshing out the story. But the practical reality is they can use it that way anyway. And so that's what I think this was. She was getting him nailed down on this story. So now she knows not to ask these questions in front of the jury. She'll get the bad answer. We came back after lunch to circle back on the lack of briefing materials, just confirming nothing in writing about the security plan, no tactical operation plan. We clarified that this officer had been on the SWAT team, but he was not a sniper, so he doesn't have particular sniper training. I'm sure he's worked with snipers, though. He's not aware of any other guns confiscated at the scene that day. Don't know if there were or not. He's not aware of it. It's not in evidence that there were or not. So we don't know. It took him about 30 seconds to get down the stairs by the tent. Again, the holster was up higher than where Charlie was. By the time he got down the stairs, Charlie was already gone. They had put him in the SUV, did their hasty exit, as the next witness calls it, and they had left. So he just kind of reiterates he was trying to preserve as much of the scene as he could. He physically pushed people off of the grass area because he's thinking maybe there's a shell casing. Maybe there's other evidence. Shell casing might give you some information about the location of the shooter, because the casing is typically going to eject back and to the right. If it's a right-handed gun, there are left-handed guns that will eject the other way, but more rare. So typically it's, as long as it's undisturbed, you can get like a general, within many feet, of course, not a super precise, but at least a general idea of where the shooting took place from. But that's only if you don't have a ton of traffic and a bunch of people kicked at different places, on their way out of the area. So that's why he's trying to secure it. He's thinking about a shell casing. He's thinking about what that might tell them about the shooting. And since he also at this point was thinking they had a suspect in custody, it would have been a close encounter. So it would have been in this grass area that would have happened. But it was when he saw the empty holster, he says, is when things started to slow down. He was in fog of war. Very normal. Everything's chaos. Everything's weird. But things started to slow down and he was like, wait, it was a rifle shot. It wasn't a pistol. It wasn't a close range thing from right here in front of the grass. It was a rifle shot. And so Low-C Center, where he went to. His body-worn camera was on the entire time. And notice, Kathy knows about it and she's seen it. She watched it because she described it. Okay, so the defense has access to an awful lot of stuff that we don't otherwise hear about. It was on the whole time except that it died. I saw a lot of comments in the chat while this happened about the really terrible battery life for the body-worn cameras. This is super common. This is super common. I really don't know why. I mean, I in general expect batteries to not really be very good and to not have a very long life. And if it's running video constantly, it's going to take a lot of energy. But at the same time, like, okay, my cell phone, no longer brand new. 1.5 years old now since I've had it. Still holds the charge while I'm using it for a good solid 10 hours, 8 hours. I mean, how can you, if the battery in this thing can run that, how can the cameras in these body-worn cameras be so bad? Hear that a lot. I'm a little skeptical. Not saying there's anything nefarious. I'm just saying it seems to happen a lot when it seems like it shouldn't. And it seems like there should maybe be a better explanation for why that is. There was some law enforcement officer who went with him to the Low-C building when he decided to head that way, but he doesn't know who that was either. So this I find a little bit strange. We have the deputy on the roof. that the random female deputy from the county that he handed over the security to. We have the unknown law enforcement officer that accompanied him to the Low C Center. We're still talking about like within a very short period of time after the shooting, right? Shooting happens. 30 seconds later, he's down the stairs. He's clearing the grass. I guess he sees the guy who's having the seizure, pushing people out of the scene, sees the holster, realizes Low C Center. How long did this take? Couple minutes, maybe? 3 minutes? 5 minutes? I guess that's enough time for like a whole bunch of other cops from other departments to respond to the scene. Because before this, it's only UVU, right? That's what he said. It was just UVU providing the security. So a lot of cops got there real fast. I kind of noticed that at the time. I'm like, I got to think about this time frame, because if there's some unknown officer there, like really super fast, what's he doing there? How did he get there? How is that consistent with just the UVU being the security? But I guess if it's 5 or 6 minutes, that's enough time for other law enforcement to respond and be on the scene. Another, like, asking the question, better to ask the question you don't know the answer to right now versus doing it at trial. Did you check the camera to see if anybody else got on the roof? Did you check it to see if anybody else got on the roof? He says, no, he didn't review the video. He says there were other people up there looking for an individual who ran that way. I'm like, well, when was this? When was this? Are you saying there were other people who went to the Low C Center roof between the time that the man jumped off and you got there? Or are you saying after you got there? The timing on that was not particularly clear to me. But he did not check the camera. He didn't check the camera first. Now he says he checked it after, didn't see anybody else on the roof. But as far as like checking it first before he went, he did not. From the point of putting up the tape, he was confident it's secure. He's confident. Why? Because he left it to another cop who he doesn't even know. No spent casings on the roof. He saw this prone position. He's aware that some kinds of guns will automatically expend the casing, automatically eject it. Not a bolt action rifle, though. You got to manually eject it with a bolt action rifle. So he did not find any casings. He also did not find any bullets. Asked if he was aware of other bullets being found at the scene, he says no. This is not establishing that there were other bullets found at the scene, just like it wasn't establishing that there were other guns seized. It's just establishing that he's not aware of anything if they were. But the if has not been established. Not real clear to me what Kathy is doing or where she's going with these questions. It's not clear to me if she's asking these things because there were, in fact, other bullets found at the scene, and so she's trying to introduce doubt. Or is it possible that she is simply trying to narrow what we are concerned about in this case, right? This is the only gun to be concerned about. These are the only bullets, to be concerned about, the ones that would have been fired from here or something like that. We can refine this down as being the point of interest. It's not clear to me, but many possible interpretations of this particular line of questioning. So now is where the body-worn camera ends, and he thinks the battery died. As far as the video that you could see of the person on the roof near the gravel disturbance, you couldn't see the person's face, couldn't see the height, couldn't see any markings on the clothing. He says there is one of the photos of the impression has a measuring tape next to it. He was not present for the measuring, but it was there in the photograph, and that was presumably intended to show the person's height. Interesting that Kathy is calling this out. Seems to suggest, I don't know, is she going to say it's not consistent with Tyler Robinson's height? Don't know. As far as weight, can't estimate, but just the person was skinnier. He says he saw a long black object in the left hand of the guy as he ran across the roof. So it's a rifle-shaped object. Once again, Kathy kept kind of digging herself in a little bit deeper. Like, really? You saw a rifle? Yeah, it was long and it looked like the shape of a rifle, long and thin. It's just kind of letting him reiterate what he's saying over and over again. But he didn't mention in his report seeing a gun or an object in the person's hand. Does that matter? I don't know. What does the video show? That's kind of the bottom line. What's the jury going to see on that video? He says he only saw it a couple times, maybe twice. The last time was months ago. He hasn't reviewed that video recently. Says he could see an object in the left hand. It looked like a rifle or something, a skinny, long object. Had a towel, something like a towel covering it. So he left campus around 9 p.m., came back the next day. Nobody knew who the shooter was either day when he was there. Exhibit 35, he's asked about. Do you know what this is? Do you know where it came from? Exhibit 35 is not on the list. So, can't tell you yet what this question is about. What's Exhibit 35? I'm going to make a little note. And maybe a little note for my carry into tomorrow. What's Exhibit 35? Oops. Dropping stuff all over here. The exhibits 1 through 3 that came in, the photographs, the aerial photographs, those were taken by a drone that was operated by a Provo PD officer. They were taken just a couple weeks ago, so they are not accurate to the time of when this incident took place. Could that matter? Maybe. We know there's been a little bit of alteration to the scene. So it's not necessarily going to depict things the way that they were when the shooting took place. Melissa Richards, again, told him that she took the night pictures and said that's what everything looked like. He saw the photographs of the night pictures the first time a couple weeks ago, talked to her about it, didn't do any kind of supplemental report. That is it for Kathy. So then we go back to Mr. Grunander for redirect, and he is just pointing out on the exhibit where the holster was found. It was up in that top level of the amphitheater, not down at the bottom near where Charlie was. That is it for redirect. I appreciate a nice, tight, tailored, single point redirect. Most of your redirect probably doesn't matter, but if you want it to matter at all, keep it tight. Don't drown us in more stuff. Just make sure we hear what we need to hear, and that's good. It will stick with us that way. I'm impressed with Mr. Grunander so far as a lawyer. Everything that I've seen throughout the course of the case, including today, his handling of these witnesses. Yeah, there's snafus about things are getting published before they're admitted as exhibits. But this seemed to be a little bit of disorganization, at least as much as anything else. I find his questioning very effective. He's got a logical, systematic approach to things. He's good with the witnesses. It's hard for the prosecutors because they can't ask the leading questions. They have to ask the open-ended questions, and your witness doesn't always know where you're going with the open-ended questions. So you have to have prepped. And if you haven't prepped that well, then you need to be really, really, really good at asking open-ended questions that are still closed off enough that the witness knows where you're trying to go and can help you out. He was good at this. Next witness. I was not at all impressed with Mr. Sturgill, the new prosecutor for today. So David Hull, our next witness, he was from the Department of Public Safety. Is that his name? Did I say that right? Yeah, Agent Hull. David Hull. He is now with the Department of Public Safety, but before that, he was a major crimes investigator for SBI for 7 years. He is a commissioned law enforcement officer. He has had training around homicide investigations, other serious crime. He's led them and been involved in probably 40 of them, he estimated. So he was working on September the 10th. He was called to respond after the shooting. He was told this was happening. Charlie got shot. He himself was not familiar with Charlie Kirk at this time. This is why, guys, I'm telling you, like, there will be prospective jurors who don't know anything about this. There are people out there. Don't pay any attention to any of this and don't care. He was in the Taylorville office. I don't know where Taylorville is. Where is Taylorville? I guess I took my map down, so I'm not going to pull it up. But he was elsewhere, and he was called in to respond, so he did. SBI, he explains, is the investigative agency for everybody in the state who needs it. So they are just kind of there. They will assist any local agency that wants the help. It's normal for them to be called out to do that type of assistance. So he assumed his purpose in being called out was to process the crime scene. When he first got there, he was not familiar with the campus, but he has since become a lot more familiar with it. He found a large law enforcement presence. There were feds, there were staties, there were counties, there were cities, there were local, there were people from like every level of law enforcement there. We know, we've seen the exhibit. That's the state's list of, or it was the defense's list of all the different law enforcement agencies that have provided discovery. It's 28. 28 law enforcement agencies involved in this investigation. So at some point his role changed because he was told that himself and Agent Davis would be taking the lead on the investigation. They pulled the short straw. You just got called there to respond, thought you were going to process a crime scene. Nope. Enjoy your case. Enjoy your case, sir. No pressure. No pressure. You'll be fine. Oh, poor guy. So as the lead investigator, he directs and coordinates the investigation and the information that's received. You mean you might like suggest actions that your investigators should take, like witnesses they should go interview and stuff like that? Is that what you mean? Is that what a lead investigator does? I'm just not getting over my my snark on the Karen Reed case. They just bullshitted us so hard. I'm not going to get over it. I'm going to rub their nose in it every opportunity I get. Yeah, that is what a lead investigator does. It is typical, normal for the scene to be chaotic initially. Yeah, definitely is. And so his role is to organize and coordinate with all of the agencies that are there. So he assigned 4 different categories of assignments to different agents. First, there were the crime lab or CSI types of people that are there to coordinate with the forensic evidence collection and transfer. Assignment to review the UVU surveillance footage. Assignment to do an area canvas around the campus. This is the door-to-door. You got any doorbell footage? You see anything, hear anything, that type of thing. And then assignments to basically assist with the flow of information is how he put it. I think this means like interviews and stuff like that. Performing them, following up on them, determining what to do with them, collating the information, all of that type of thing. So at this point, the campus was locked down and secured, and so they brought the crime scene people in. They will not bring the crime scene people in until it is safe for the crime scene people to be there. They also typically won't bring in the first responders until it's safe for the first responders to be there. So the people that are coming in on the ambulance, if there's an active shooter, cops aren't going to necessarily let them in until they know they're safe. This is just kind of the priority of what happens at the scene. So the first priority was identifying who had been involved in the shooting, his priority. So they got lots of information from the general public. They were getting people sending videos. They were monitoring social media. They were just basically trying to stay ahead of the flood. He got a cell phone video from Amber Wright, who we thought was Amanda. It's a common mistake. I understand. Not everybody remembers what their favorite movie starring Amanda Heard was. Not everybody remembers that. So unfortunate. So he arranged a time to collect that particular video. He made notes, did a timeline, and apparently on April the 6th is when Wright was contacted. He met with her. Davis met with her to get the 1102 statement on April the 7th. He said some edits were made to protect some participants in the video. It was originally provided to Mortensen on October the 8th. Or maybe that's when she contacted them with the video, or they made contact and then they received the video on October the 11th. And so he met with her then to verify that it was accurate, do the 1102 statement. That's part of their preparation. So that Mortensen, that was who was previously on the witness list, but now apparently they're not intending to call him. So Kathy objects to this one under the rule 4-202.02. She's arguing this should be safeguarded or it should be protected. It's hearsay, but also it's one of the types of documents that is not automatically public. This is a very extensive rule. I talked about this a little bit on the stream, but now we will look at it. I will show you what this rule is, because this is how they handle sealing records, basically, in Utah. They just have everything under the sun categorized one way or the other. The presumption is it's public. And so public things include, but is not limited to all of these things. So that's our very first status, section 2, what's public? A lot of stuff. What's sealed? Sealed is the highest level of protection. It basically means only the court and the court's staff get access to these records. Very specific one, adoption records, gestational agreements. These are like surrogacy contracts and things like that. Consent required for abortions performed on minors. These things are all sealed. These are not public. Actions for disease testing. You're going to, compulsorily test somebody for a communicable disease. Not going to be public. Expunged records. Pen and trap. Pen register or trap and trace devices. Identities of confidential informants. You get the idea. A lot of these types of things. Private is a lower level of protection. I forget exactly how it's broken up. I think the attorneys get access to this too, but like anybody else needs like special permission or something like that. So different, very specific things that are private records. Involuntary commitment orders. You're going to be sent to a mental hospital against your will. That's going to be non-public, but your attorney gets to know about it. So those types of things. I mean, look at all this. Jail booking sheets. Personal identifying information, driver's license number, social security number, etc., etc. All of those types of things. These are classified as private. This is the only one that's going to matter, really, in all of this, as far as I'm concerned. 4R, private, photograph, film, or video of a crime victim. This is the reason. If this rule applies to the exhibits, this is the reason why we are not going to see the videos of Charlie being shot. It's because of this right here. If it applies to the exhibits, we'll get to that particular argument. So these are all the things that are private. Protected, again, it's less. The attorneys get it. Maybe some social workers and things like that. People with like a need to know basis can get it. But otherwise, it's not going to be generally public. So, work product stuff is only protected. Privilege stuff is only protected. Court security plans protected. Maybe I have it backwards in terms of like the level of protection. I don't think I do, but I could. This is the one that Kathy loves. Okay, these records were created and they would interfere with fair hearing or trial. Interfere with a fair hearing or trial. If we know about it, it would interfere with his fair trial. This is kind of her catch-all for everything. So this is why Kathy argues these things should be public. All this stuff, juvenile social court records, juvenile court legal records, safeguarded records, another category of things that we don't get. This is the rule. Scroll, 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 scroll. Find the one that applies to the document that we're talking about, and where does it place it? So Kathy was arguing this one right here, 5J. She also argued one of the 8s. I think the one that had the minor information, images of a minor, perhaps. Maybe it was the victim or witness, had their contact information. So she's saying this rule applies because of that. These exhibits should not be published. They shouldn't be, she's saying they shouldn't be admitted, but also they shouldn't be published because they fall under these rules. So state disagrees. They say, Mr. Sturgill says this was a properly collected statement under 1102. The court takes a look at it. State is arguing that this rule here that we're talking about, this deals just with publication. This isn't going to the admission. This is just going to who gets to see it part. So it's not really about admissibility. He says the personal information has been redacted. Judge is like, no, it hasn't. Not on my copy. They got to go hunt down the redacted one. Let's not offer this one because this one has her full information with her name, her address, her social security number, all of that. Let's maybe not put that out there. Let's maybe be a little bit more attentive to our exhibits. Once they're in, argument to be made, there's their public record. So do be cautious. Kathy then says, oh, by the way, I also object because there's clearly 2 different authors in the body of this writing. There's like one handwriting, one line on the top, and then the rest. And there's nothing about that. You know, nothing about, we don't know who wrote that one line. And the judge agrees. The writing does appear to be different. Do you want to lay additional foundation? Yes, he does. So we ask the questions. Yes, it was a different author who wrote the line. They wanted her to verify a specific video. So they wrote down the specific file name of the video before showing it to her so that they get it right. Seems pretty straightforward and not really that controversial. Reasonable explanation. He said it appeared to be Davis's writing. And so with that, Kathy's objections are overruled. He says the redacted version complies with the rule, and so they are admitting Exhibit 61. So Ms. Wright, whether she's Amber or Amanda now, I don't even remember. She's Amber. Amber Wright did confirm in the statement it was her video. It shows her and her 2 young children. This is when we have the interjection from Kathy because now Exhibit 61 is being showed. We've started to get to see some of the exhibits. The camera's panning over to the screen, and Kathy's like, "They're doing that. I thought they weren't going to do that. Now they're doing that. Make them stop, judge." And the judge is like, "This is why I told you we have these different categories of the objections. And so if you are objecting to publication to the media, you need to say that. You need to raise that so that we can rule on that specifically." State pipes up. It's their position, Mr. Sturgill, that these are public records. They should be published to the public. The Wright video itself is a view of her position in the crowd. It shows the amphitheater. It shows the background. It shows the crowd. He's saying basically this is not a graphic video. No violence in this one is the bottom line. The judge wants to know. Are we going to see a shooting on this video? No, that's all he needs to know. So it's offered. He wants it to be published to everybody. And again, we have the objection to the foundation, the authentication, the one that we know is without merit since 1985. Also objecting to the publication of it. We turn to the Rule 901 that we've already looked at here. The authentication is satisfied. We already know that. Kathy then goes back to the this rule, the 4202.02, and arguing that because this shows a crime victim, 4R, that's the one, the photograph, film, or video of a crime victim. Being a little loosey-goosey with the definitions here, right? Because Charlie is the direct victim, right? Are the other people there victims? Like how distant do the victims get? She's like, well, the prosecutor is arguing that they're victims, you know, for purposes of saying like they justifying the aggravator, you know, the death penalty aggravator. They were there, could have been, you know, could have been in the line of fire and stuff like that. That's what she's getting at. I don't think that's really what this is about. I could be wrong, though. The state says it's fine because the faces are blurred out. You don't actually see them. And the judge is like, well, not all of them were. Not all of them were. So he admits it, but he does not publish it in court. This is now where the news media steps up. The news media's attorney is like, okay, judge, we got an issue because this is going to keep coming up and we need to make our record that this classification rule is not about in-court exhibits. It is about documents that are filed. And I think he's got a point here. The reason why you need separate rules for documents that are being filed in the file from documents that are being admitted as exhibits in court is because there's no oversight by the court about does this make it into the public record or not when it's just going into the court file. If you don't have this rule in the system like this, people can file whatever they want. And it may or may not be relevant. It may or may not be helpful. It may be their defamation laundering. Talked about that before. People just file bullshit in the court because it's protected under litigation privilege. And then somebody can pick it up and publish it, write a story about what they found in a legal document somewhere. And it gets protected all the way. Now there's perjury, but we all know how many people actually get charged with that. So I can see why it's a different issue. A lot of different reasons. Court doesn't have oversight over people's decision to file things into the court file. He does have control over what makes it in as an exhibit and how it gets handled. So he's got the screening ability himself. There is also the distinction. The adjudicative records, the judicial records, the things that he relies on for purposes of making his decision, these get the extra, maybe First Amendment protection, but certainly common law public right of access to these particular documents. Not everything that gets filed in the court file is a judicial record. So not everything that files in the court file is something the judge is going to rely on to make substantive decisions about the case. There's a lot of procedural stuff. There's a lot of background stuff. Not so much in our criminal cases. Boy, in those civil cases, there is griping about discovery. Not all of that is going to qualify for the same level of public access because it's not stuff the judge is relying on to decide the case. Exhibits are. It's literally why they exist. So we got to presume much stronger public interest in the in-court exhibits than things getting filed in the court file. So the media lawyer is saying it's a fundamentally different thing to present evidence that you're relying on and then deny public access to that. He's right. That's a very different implication. He's saying this particular thing is not so prejudicial that it can't be seen in public. And the public is entitled to see what you're saying. Kathy has nothing to add to that. Mr. Sturgill says, also, we think the defendant has no standing to assert the interests of victims. Love it. Love it. Played that card myself within the last couple weeks. Standing to assert the interests of the victims. Judge says, I do see the differentiation. He sees the distinction between in-court exhibit filed, appreciates this argument. I'm glad that it was made. It is an important distinction. So now he says it can be played in the courtroom, but not captured on the video. So now we do have a little bit of a distinction between, there is going to be some stuff potentially that people in the courtroom are going to be able to see that the rest of us can't. And so we'll be relying on them for their description. This particular one, I'm honest, I as far as I can tell, the reason why it's being shown is just to show that kids were present, because that was one of the aggravators in the presence of children. So it's not otherwise, I think, super probative of much. So I don't really mind that I can't see it, but the principle does matter. The principle kind of does matter, because just because I don't personally particularly care about this one doesn't mean that other people don't, and it also doesn't mean that this principle isn't going to be needed for an exhibit that really does matter. He got a cell phone video as well from Mr. Phillips. This was from Agent Schultz. Got it on September the 29th. This was a video of the shooting. There's an 1102 statement that is associated with it, Exhibit 7.1. Kathy objects to this one very much. It's a close-up view of the shooting. It shows grievous injuries in stark relief. It's graphic. Same issue with the publication. It's private. State is saying it's a public record and it should be published. But we're now, remember, Kathy got a little ahead of herself. She's objecting to the video, but all we're really talking about is the witness statement. Prosecutor's like, that's not in the statement. That's not a problem. The statement itself is fine. So the statement is admitted, published, it's fine. We get to see the statement of her saying, yeah, this is, or Tyler and his mom saying, this is my video. It's accurate. But the video itself, it is graphic. He was towards the front of Kirk. It depicts the moment Charlie Kirk was shot. So it is not published due to the sensitive nature, but it is admitted, and the judge watches it. So then he also collected the Turning Point USA video. They had their videographer there, Terrell Farnsworth. They got the 1102 from him. He is the owner-operator of the Visual Impulse, the videographer that was there documenting the event. So we get his 1102 statement in over Kathy's standing objection. She says she wants to cross on the quote-unquote alteration of the videos because she says it's clear that clips were being made from the longer video and we don't know who made them or how they were made or anything like that. Clipping is the classic alteration of the video for purposes of efficiency. If there's 5 seconds of the video that matters and an hour and a half that doesn't, don't make everybody sit through the hour and a half. Just don't. Let's find a way around that. Nobody wants to do that. We will if we have to, but it's just a good way to lose everyone's attention and interest and just waste a lot of time. So that's why people clip things, kind of normal, but also, yeah, I understand she's going to object to it. Doesn't matter because the bar for authenticity is so extremely low. So he allows this one in. The statement can be published. The video itself, graphic again. It's a view from behind. It shows the crowd. It shows Charlie engaging with the crowd. It's admitted based on specifically invoking the victim's rights to respect and dignity under the Utah Constitution. He's not going to publish this one. But he does watch it, and this is the one that he was watching, and you see him visibly jump and recoil. Very strong reaction to this one. Gives a bit of a clue, I think, about exactly how graphic it is. Judges had a great poker face, and he was like, get me the hell away from what I'm seeing on that video. Collected video surveillance from UVU, got some from under the Hall of Flags, and a statement from the guy who runs the security system. More objections from Kathy Nestor that are overruled, more of the same. This particular one is published, he says. And so this is showing the view looking east towards the back of the stage. I'm sorry, not the video, but of course the statement that this video is authentic and so forth. That can be published. The video itself is also sensitive, graphic. It is like another view from behind, from what they're calling the breezeway, which he described as like you could drive through the Hall of Flags, kind of underneath, to get into the courtyard area. He described that's where Charlie drove in. So it's kind of from that area, not published, but it is admitted, and the court watches it. He describes this video showing like a banner that's hanging. It's not clear to me if he's describing like part of the pop-up tent itself or a banner that is hanging on the tent, but it's part of the tent. Charlie is sat in the middle, about the middle of the tent, about 3 to 5 feet away from the banner. Immediately after being shot, Charlie's security detail removes him from the scene. They did the hasty transport to the Timpanogos Hospital. And that's happening over on the left side of the video. He's just like describing what the video shows. The hasty transport means that they took him immediately as opposed to waiting for an ambulance. I have seen stuff floating around the internet about an ambulance being on site. This would seem to indicate there was not an ambulance on site. They would have had to wait for an ambulance to arrive. It was faster to get him there themselves. He did receive treatment at the hospital, but was ultimately pronounced dead. The medical examiner had an investigator that he spoke with, and told Agent Hull that he had been at the hospital when Charlie Kirk was declared dead. This was Officer Bullock. There was an autopsy that was conducted late evening to early morning of September 10th to the 11th. Dr. Guajardo performed it. Pretty sure this is a Latino name, but it's just what it looks like. Guajardo. So he received the autopsy report, also visited with the doctor, so had chats, got information about that. It's a standard format, this report. They have a form. They fill out the form, basically. And so there's nothing unusual about this one. It's in the same form that they always are. It is admitted into evidence, the autopsy report, but there are, according to both parties, very personal things in there that should never be published. Things like medical conditions and history and the condition of his body Kathy doesn't want us to know about. That I kind of think we may need to know about. We will at trial. May not be published, but we'll hear about it from the medical examiner. But it does get admitted. It's not published. No contribution from our media lawyer on this one. He wasn't going to argue that we should get to see the autopsy report. All they care about for this purpose is that it states a cause and manner of death. He says the cause of death is it's murder by a gunshot wound to the neck. Murder by a gunshot wound to the neck. That's not it. Kathy objects to this. It's not murder. It's definitely not murder. Murder is a legal charge. It's a specific type of homicide, but a medical examiner is just going to decide, is this a homicide? Is this a suicide? Is this an accident? Is this death by natural causes? That's all he cares about. So if it's a homicide, that just means it's a death caused by another human being. That's not accidental. Could be negligent, could be reckless, could be intentional, could be a lot of different things. And those are what determine whether it's murder, manslaughter, not a crime at all, valid self-defense. But homicide is the manner of death. So it is an important distinction, Kathy says, and she's right. Yes, it is. Medical examiner definitely did not find murder. So in the course of performing this task of trying to identify who's on the roof, he reviewed hundreds of hours of video surveillance, all focused on trying to track the individual on the roof before and after the shooting. Eventually, on the evening of the 11th, he got word from Washington County that an individual wanted to turn themselves in. That individual was named Tyler Robinson. He gave that name to the information analysis group, that assignment that he had made. And he did that to get public records, Department of Licensing records that would show his address, have a picture of him, assorted vehicles, associated vehicles with him, and stuff like that. So they were able to get a photo, an address, a date of birth, and a DMV record for a silver Dodge Challenger that was registered to Tyler and his mom. That Challenger is going to have a license plate. It's going to have a model year. It's going to have a lot more specificity than we're getting right now. But for their purposes, that's all they really care about, because they're using that to show that then when they were looking through the UVU video and kind of expanding the search of that video, they located the Challenger. They find a Dodge Challenger, silver, I think it's his. So that's part of their video canvas. From this review, they found that on September 10th, Tyler Robinson, they allege, was on campus about 4 times throughout the day. He was there twice before the shooting, once during the shooting, and then again afterwards in the late evening, spilling over into the early morning hours of the 11th. That was new. Didn't know that. Not shocked, but didn't know that. They also tracked the Challenger before and after the shooting, so followed the movements of the car. We get first a video that is taken about 12:30, about 30 minutes after midnight on the 11th. He got this video from Olson, has watched it a couple times from them. This is UVU surveillance footage. UVU alone, he says he watched about 16 hours, or they were able to compile about 16 hours of somebody believed to be Mr. Robinson. This is going to be a collective, right? If there's 4 times he's on campus, then how many different cameras are capturing him at any point in time? And then he's going to move, and a different camera is going to pick him up, and maybe another camera is going to pick him up. So this is going to be, repetitive. It's if you watched all of them happening in real time in the time in which they took place, a whole bunch of them would be happening at once, and so it would be much shorter. But if you watch it back to back to back to back to back, and you're watching the same thing over and over and over again from different angles, he says it adds up to 16 hours. That's a lot. That's a lot. I mean, there are either cameras freaking everywhere constantly, or he spent a lot more time on this campus than I guess has previously been expected, or maybe both. Maybe both. He's asked if he can identify the person that he saw sitting in the courtroom. Kathy objects to this as being a suggestive in-court identification. This was a very creative objection. She's not wrong. In-court identifications are inherently suggestive. There's only one person sitting here looking like a defendant for you to identify. You already know who it is you're supposed to point at and say that that's the person. She does have a point. They're always suggestive in court identifications. They are also routinely allowed. Courts throughout the country. Don't know if that's really changing. Maybe they're going to be making an argument, legal argument, that should change, given how much more we know in this day and age about human memory and suggestibility and the way that memories can be tainted and things like that. That objection is overruled, but then we don't do the identification. We don't do it. He just kind of leaves it sitting there. He goes instead to Exhibit 12.1 is a compilation of the UVU video that he obtained that depicts the individual he believes to be Tyler Robinson. There are some parts of the video that they have zoomed, they've altered it. They've zoomed in, they've drawn red circles to show what you're supposed to look at. They've blurred the individuals, but it's basically throughout the day that Tyler Robinson was on campus. So Kathy objects to this one because Mr. Hull, Agent Hull, didn't create the compilation, and so he can't attest to the accuracy of what they were derived from, but also the alterations haven't been explained. He didn't do them, and so there's not a sufficient authentication for those. She also doesn't like a lot of things. She thinks it's protected under one of these privacy rules as well. I don't know why I have that still up there. Sorry, guys. It's protected under one of those provisions, but also she doesn't like, she says it combines clear photos with less clear to say that they're all the same person. Oh, shades of Hyundai Elantras, perhaps? Some real clear and crisp, some not at all, some just sort of like a blur, perhaps? They will need to explain why it is that you are concluding these depict the same thing. So I expect them to be prepared to do that. Probably not at this hearing, but certainly at some point. And then lastly, she says this is going to be prejudicial to potential jurors. Why would it be prejudicial to potential jurors? Why would it be prejudicial to potential jurors? Are we going to see real clearly for ourselves that Tyler Robinson is on video on the campus where he has no other real explanation for being? Is that why it's going to be prejudicial? That tends to seem to me why it would be prejudicial, because the defense is only going to be concerned about prejudice that goes against the defense. If the prejudice is against the state, it means this evidence makes me think he's innocent. The defense is going to want me to see that. But if it's going to make me think he's guilty, they're going to not want me to see it. Prejudicial. I'm going to think he's guilty. That's what is being said in the subtext here. So at least some of this video, perhaps not all of it, but at least some of it sounds like, and we know this from the previous description in court from Mr. Ballard, I think, was describing, giving the court a proffer of what they expected to show at this hearing, and he describes it. Some of this footage, the morning footage, very clear, crystal clear. It's really obviously him. So that's the nature of that objection. The judge wants to know if there's a copy without the alterations, because nothing in the witness statement explains who did the alterations, what they did, what they consist of. The prosecutor is like in a mess. Well, no, I don't have another one. There was all of them said that the witnesses watched the footage and it was accurate, and what the alterations are is fine, and I can call the person who did the alterations. You can, but you didn't, and that's not where we're at. So at this point, the judge has sustained that objection to this exhibit. It's the only exhibit so far he's sustained an objection to, and it is curable. It is curable. His problem here is with the alterations, and so they either need to lay a foundation for what the alterations are and who made them and how they differ from the original, or they need to just present the original. Those are kind of your options. So he describes, four visits to the campus that we already heard about. Then he also collected Ring doorbell footage from the surrounding neighborhood. Okay, this is where we get to the map, because the video that we got was from 925 South, wherever that was. I think that was part of the horseshoe he described. It was consistent with vehicle parking, showing a vehicle parking in front at about 38 minutes after midnight on September the 11th. They got this from the canvas in the area. It was collected from the Nobles, the name of the homeowner. So there is an 1102 statement from them that's on the witness list as well. This video is a nighttime view from the porch across the street from the house of the homeowner, looking out across the street. They were interested in this video, collected this video because Tyler Robinson had an interaction with law enforcement, which I'm like, we did know about this because he mentioned it in the text. It's in the text with Lance. And shortly after, a vehicle came to that house, and with other things like cell phone data, put Tyler Robinson in that area. So we captured it on video. It's the first thing we've heard about location data. I guarantee you it is not going to be the last. Cell phone data, location data, whether it is GPS from the phone itself or whether it is cell site location information from the towers, the pings, and all of that. It would be better if it's GPS because it would be more precise, more than likely. But even if all they can get is pings, they're going to use the pings because they are going to use the location data to corroborate all of this video. They're going to show these things line up. Video shows him here. Phone shows him here. Look at that. They correspond. That's what they're going to do, and that's how they're going to build this case. So it is not going to be the last we hear of cell data, particularly because if that's not the case, if he's innocent, he wasn't the guy on the roof taking the shot, he was somewhere else, the defense is going to bring it up. One of them is going to bring it up, one way or the other. The location data inculpates him or it exonerates him. So we're going to hear about it. This sounds like corroboration from the way that Hull described it. Video had this interaction with law enforcement combined with the cell phone data. They knew Tyler Robinson was in the area. That's why they did this neighborhood canvas. He says the vehicle has distinctive wheels. That one. I can't blame him for not knowing how that one just doesn't sit right with me. Distinctive wheels. Don't pull your distinctive wheels on me after you pulled that shit with the Richard Allen case. It was crap. It was absolute trash. He says so. I'll keep an open mind. I will hear more. But we got to see this video for ourselves. We saw this one. Various clips showing different things with the vehicle. Lights on, lights off. The vehicle is far away. It is dark. It is hard to see. When the light comes on, it like blinds out other stuff that's going on. Not sure I'm buying the distinctive wheels based on this. We'll see. We'll see what else there is. They describe the clips as showing him parking and then getting out of the car and leaving and then returning and then, you know, unlocking the car and then leaving the area. I didn't see him get out of the car. Okay, the video is that bad. Maybe you guys did. I didn't see that. I see the car pull up and stop and the lights go, you know, on and off. I didn't see him get out of the car, but maybe y'all did. He believes he can identify Tyler Robinson's vehicle from this video based on its shape and those distinctive wheels, right? Because Tyler Robinson doesn't drive the only Dodge Challenger, not even the only silver Dodge Challenger. Okay, I was thinking to myself, when did Tyler Robinson sign up to boot camp and get his bonus? Because that's where I expect to find the Challengers. I expect to find them in the signing bonuses from the people that are getting ready to head to boot camp. It's not the only one, so you got to have some reason to think this is his and not just somebody who happens to own a silver Dodge Challenger in this neighborhood going home. It's dark. You can't see the license plate. That's why he's relying on these distinctive wheels. Distinctive wheels. That might be good enough for right now. May or may not be good enough at trial. Location data would be far more helpful if you bring that out and show that his location from his cell phone corresponds with where this car was. So he explains that it's in some reflective panels on a dumpster is where you see the passenger get out. Like you don't actually see the passenger get out directly. You got to be looking at a reflection in a dumpster. I was not looking at any reflection and I don't even remember seeing a dumpster. So I guess that's why I didn't see the guy getting out. Okay, you say so. I didn't see it, but it's not my call, so we then had the recess. They had their little they had a conversation at the bench, and then came back where their the ID came back up. It's like, well, if the court will just put on the record that Hull already identified him, then we'll leave that done. We'll leave it. Confusion about was the in-court identification actually accomplished or not. He didn't ask. So it didn't actually happen. There was never a moment before this where Agent Hull was like, that's the guy. Tyler Robinson is the guy I saw in the video. So it's like, hey, if that's all we want, we'll be done after that. All we want is to put on the record that that Hull identified him. He's allowed to do his in-court identification for purposes of this hearing. So he does it. The prosecution explains also their intention with this video compilation, the clips from the UVU surveillance that they put together to show what they say is Tyler Robinson at all these different times on campus. Not admitted because of the alterations. So he says his intention now is to prepare an original of the video that's in the dispute. He doesn't have it right now, can't do it in the time that's left. And they will bring it back tomorrow. And then he wants the court to look at both of them. So the idea would be, he says, our intent is to admit the versions without the circles and zoom and everything, but also admit the edited one so that he can compare it to the original. And then he would be able to see for himself. Here's the alterations, and you can, weigh to what extent they affect, the validity of the evidence. Judge is like, I'm just going to wait on that. I'll wait until they're both in front of me and make the decision. Kathy has one more thing, which is that Agent Hull is the lead investigator, but he is also still testifying, and so it would be improper for him to discuss his testimony with the prosecutor before he is recalled to the stand tomorrow to continue his testimony. So he is admonished by the court not to do that. The state doesn't object. That's proper, appropriate. You shouldn't be sitting down in the middle of testimony with your witness and telling him everything you got wrong and everything you forgot, and here's what he should fill in next time when you get back into the questioning and all that. Not really what it's for. So that concluded our day for the day. Little bit of procedural chaos, but honestly not really that bad. Not really that bad, everything considered. It's like the worst is that you publish a few things that are kind of innocuous before they were in evidence. You're not really doing too bad. A lot of those objections and the repetition, it really is, I think, running the risk. You condition, you're going to condition the court that as soon as you stand up to say object, it's like, oh, bullshit's coming. You really don't want to do that. It's a strategy. I get it. I just don't think it's wise. I don't see particularly good trade-offs here. I don't see a good argument that these are really very valid objections for the most part. The stuff about not publishing, I get her argument too about the rule, whether it applies to the exhibits or not, questionable, but I certainly understand her argument about it. But yeah, no authenticity for the photograph because the photographer isn't testifying. No, that's bullshit. We all know it's bullshit. It was without merit in 1985. 41 years now it's been without merit. Longer than you've been a lawyer, probably. You should know that. It's not a good objection. So, what upside are you getting in exchange for teaching the judge that when you say objection, he can tune out whatever you have to say next because it's gonna be nonsense. It's gonna be bullshit. I don't personally. I would not do this. That's all I'm saying. I'll do the Monday morning quarterback thing. I wouldn't do this. It's not my style. Um, yes, you want to be thorough, but you gotta keep it with stuff that matters. If the judge doesn't think what's coming out of your mouth is important, you're in a bad position. That's just my perspective on it. I'm still skeptical of this sniper pad. I'm skeptical of these unique wheels. Skeptical of some of the details, but all in all, are they really going to matter in the grand scheme of things? Probably not. Probably not. They're relatively small. And at the end of the day, it's just going to come down to the layers of corroboration. We're likely to see video tomorrow. Reason to anticipate it's going to very clearly show Tyler Robinson on the UVU campus that morning. And the rest is just going to come down to how many pieces of evidence support each particular proposition that goes into the state's theory. That he was there in the morning, came back for the shooting, did the shooting, confessed to the shooting, stuck around for a while and then left, turned himself in, etc. At the end of the day, is it really going to matter that much if I'm like, that's a misleading photo of a sniper pad, look at the shadows and stuff like that? Probably not. But I just do pay attention to these details. I kind of have to. Gotta think about this kind of thing. Open question about, so are there other bullets and guns at the scene? What's up with those questions? Are you just narrowing our focus to make sure that we know that this is the important area because it's the only area where you found anything? Or are you implying there was, in fact, other stuff out there that you're saying might be important, might be reasonable doubt? Not clear. Not clear. So I'll be paying attention to see if we get any further clarity on that. Heard a gunshot, cause of death, homicide by gunshot wound. I would like to think those would put some things to rest, but they won't. I already know they won't. But we are now likely building into the timeline of the identification. We've already got the identification of Tyler. Like, we've heard that part. Somebody called in to Washington County, said he wants to turn himself in. So we've gotten that far. But we're going to get into the timeline of the surrender and the taking him into custody, the getting his DNA and securing his devices and all of that type of thing. Anything that they want to get into for this hearing. They might not get into the devices because they're not using the cell phone extractions. If they were, they would definitely be telling us, because it would be kind of part of the chain of custody to present that to us. Yes, we got his phone and at this time, and here's what we did with it, and here's how we handled it, and here's how we secured it, and so forth. But if they're not admitting the extraction, they may not do that. So we'll just have to see how some of those details play out. But getting some evidence about that timeline may hopefully also lay to rest some other internet chatter. Well, it's been a little bit of a long day. Just a little. Claude Simeon, thank you for doing this. I can't watch during the day. My pleasure. That's part of the reason why I wanted to do it. I do realize that it is a big investment to do the whole live stream, and not everybody is going to have either the time or the inclination to do it. So it made a little bit of sense to me to go ahead and break it up and do the more informal chit chat in the separate session. User, do you believe the conspiracy theories? I don't even really pay attention to them. I'm not interested in what's not happening in court. If there is a good theory, it will find its way into court because the parties have the incentives to present good theories for guilt, against guilt, depending on which side you're on. So I really don't pay much attention to them. I'm not interested in them. I'm interested in the case and what the evidence is being presented in this case, because any theory is going to have to account for this as well. Okay, maybe it's all a big coincidence. Coincidences do happen, but you're going to need to explain that coincidence to me. Why is he on UVU surveillance footage this morning, the morning of the shooting? Why is he telling Tyler, telling Discord, making these incriminating statements? Why did he surrender himself? All of these things have to be accounted for. It's not that there can't be a possible explanation. There can. But I'm going to expect to hear that from the defense because they're the ones in the best position to know what the defense even is here. So I'm not an authority. I couldn't even tell you like what the conspiracy theories are. I hear bits and pieces. I understand about the Discord messages are faked because Tyler Robinson was Mirandized, hours before he surrendered in Washington County, according to an undated document, for example. Don't buy that one. I understand there was something having to do with Egyptian planes going to the airport. I have no idea how that turns into a theory, like with a mechanism of how this resulted in Charlie Kirk dying. What I hear is a lot of searching for motive, right? Charlie Kirk was a high profile person. He was a controversial person. Not everybody agreed with him. Not everybody liked him. And he had a lot of influence. And so depending on where you kind of stood in his favor, it may or may not be to your benefit. So there's potentially all kinds of people with a motive to not have Charlie Kirk around anymore. But that's true of any human being on the planet. It's maybe a bigger scale for Charlie. More people know him, more people are affected by him. But there's really not very many people walking around this planet that not a single person has ever been like, I'd rather that person wasn't around. That person sucks. I don't like that person. Doesn't mean you're going to actually do something about it. But it's motive. That's all that motive takes. Antipathy. I don't like that person. But motive isn't anywhere near enough to get to proof of something actually happening. You need your means, you need your opportunity, you need a lot more than just this person might have had a reason to want them dead. Great. Then how did they carry it out? How did they carry it out? I haven't seen really a lot of that. I guess there's the exploding mic thing, but to me, it's like there's death by a gunshot wound, according to the medical examiner, bullet fragments recovered from Charlie, according to the ATF. Not seeing an awful lot of reason to think that there's anything to do with a microphone in any of this, according to this evidence. Reconcile the microphone with the existing evidence. We still have Tyler on campus. We still have bullet fragments. Good theory needs to be a comprehensive and explain everything. If you're just cherry picking things out to build a theory on, it's not a good theory. Something like it doesn't explain why Tyler told everybody he did it, So that's kind of my approach with all of that. Amy LC adding to the crazy battery of you all. Hey, we'll take all the energy we can get. Just because the body worn camera apparently has the energy of, somebody in a nursing home, doesn't mean that I can't have a lot more energy. Kyle Wilbur, 4318. Great unbiased opinion. The volume was low during the hearing. No, it's not your fault. I appreciate that. It was low. It was better, I think, on the KSL. I don't know why there's such a variety when it's all the same feed. It's clearly through whatever processing the broadcaster is doing at their end. But yeah, it's always kind of surprising. Like big difference in quality. KSL had the better boost today, so that helped a lot. But the trade-off was they don't have the captions. I want to be able to read it. How much gobbledygook is it going to come up with anyway, right? But reading the captions is often a great source of amusement, that gobbledygook. Two Truth for Liberty. How much government interest is there in preventing public view of things that were specifically intentionally published by the government for viewing by some members of the public? Well, in Delphi, for example, the press got special access to the exhibits. The rest of the public didn't. We didn't get to see it unless they chose to publish it in open court. We didn't get to see it. The press would get to go in at the end of the day and pass the bar and look through anything and everything that got admitted that day, whether it had been published in court or not. We peons without our special relationships with the anointed of the conventional media folks, yeah, we didn't get that privilege. So it does happen. I mean, is there an interest in it? There's always an interest in the flow of information, isn't there? In the management of information. You want everybody to know the good stuff about you, more sensitive stuff. Maybe you just want your friends to know that. You want people to be able to spin things in your favor. So maybe you carefully manage who you share certain things with. You anticipate what they're going to be interested in, and how would that work to your advantage? I mean, the government is an entity. It's got the same self-interested motivations as any other entity, including a human being. So government is like a corporation. It's just people. It's just people. Depends on who's in it. But it definitely does happen. Kyle Wilbur, 4318. By hearsay is all I heard today new law in Utah, right? Thought sure you've answered this, but tell me like I'm a 4-year-old now. Lol. We went through a lot of hearsay stuff today. I don't think this is a new rule in Utah. I had explained before that with the preliminary hearing, it used to be the case that they would allow the defendants to call their own, to treat it like a mini trial, to use it to like having a deposition of the other side's witness, so that you could just explore anything having to do with the case. It really wasn't limited to this, do we have probable cause or not? You were allowed to use it for discovery purposes. It was when they changed that rule that they adopted the constitutional provision that allows reliable hearsay. It is in the Utah Constitution. They get to use reliable hearsay at the preliminary hearing only. I mean, that's all that's called out. So those are related changes, but they're not real recent. If I remember, this was happening back in the 90s. Might have been the 80s. Can't remember exactly now off the top of my head, but it's not anything recent. That's just kind of the sequence of events of how it all happened. So I think that might be what you were catching. Kyle Wilbur, 4318, now talking lemonade stand. I'm not kidding. Lemonade stand. I could use a lemonade stand. I love lemonade. God, it's one of my favorite things. You got me. Drink my tea here. Welcome, Kyle Wilbur, to the channel. Welcome. Thank you for becoming a member. Appreciate your support. Two Truth for Liberty, sort of like an exception that swallows the rule. Non-testimonial equals a black hole, swallows up entire galaxies. Oh, you have no idea. The most ironic one that gets excluded from the testimonial hearsay, the 911 call. Why are you calling 911? Why are you calling 911? Because you want the police to come. You want the police to come and arrest somebody. But they'll say no, it's not for with a 911 call, it's not necessarily about getting evidence for a crime or an arrest or anything like that. It's about dealing with an emergency situation. See, so it's not really court focused, it's emergency focused. The 911 call gets exempted is not testimonial. Yeah, it's a massive black hole. I could rant for a long time about that one, but I'm gonna restrain myself. JPJH 8844. Unless TPUSA paid for advanced security and metal detectors, they aren't getting them. Charlie wasn't an important person with Secret Service protection. Oh, I know he doesn't get Secret Service protection. I am a little bit surprised that the university wouldn't do that. The university has its own liability for security on campus, its own exposure for conditions being unsafe. And that can include negligence in securing the area and screening the participants and things like that. Is it foreseeable that an armed person would show up at a school event and cause harm? I would say that's pretty foreseeable in 2026. It unfortunately is just not that uncommon anymore. And so, yeah, I think there is a very decent argument to be made that, UVU has some kind of obligation to provide reasonable security measures for screening the audience. Didn't do that here. This is happening on their premises, so that's why they bear responsibility for it. But the devil is always in the detail with those types of things. You can responsibilities can be shifted with the contract and things like that. So, I mean, very, very hard to say, but I agree. Best way for this to have happened would have been for TPUSA to do it. Just pay for it themselves, do it yourself. That's kind of the issue with the security is, yeah, if you're going to depend on other people, you really are at their mercy. And if you don't want to be at their mercy, then you just have to take responsibility for all of it yourself. And that includes, assuming the cost and everything. So I think it's very sad. I really do. I suspect, I don't know, but I just suspect there was some naivety and some rose-colored glasses going into it. It'll be fine. It's Utah. It's a good event. Not that big a deal. We haven't really had problems before. It only takes the one time, and this was kind of the perfect storm. Just very, very, very sad, very unfortunate. Kyle Wilbur, 4318, he came down to find a better vantage point. He climbed over all of the people that were hiding in the stairway so that he could look for the shooter from ground level instead of from up above. His whole description, Officer Bagley, I give him credit for not trying to kind of minimize or sweep away the fact that there are like inconsistencies in his description, because that is also, again, normal. Like, this is normal. This is a traumatic, surprising, startling public event. It's the kind of thing that your mind is trying to be like, that didn't happen. It's trying to explain away what you've experienced. And so, yeah, it's normal for there to be like confusion and maybe, not super rational guarantee that the audience was experiencing stuff like that. there's this like idea that because he's a cop and he goes through that all the time that he'll be like acclimated to it. And that's probably true to some extent, but it's definitely not universal. And I mean, a lot of cops will go through their whole career and never be, near a gun being fired live. You don't know how you're going to react till, you're in that situation. So I do give him some credit for not like, trying to, I don't know, just bluff his way through or whatever. He just kind of leaned into like, yeah, it didn't really but it made sense to me once, like, I'm like, oh yeah, I guess it was a rifle. It makes sense. What I heard was a rifle. Wasn't necessarily acting rationally had it registered with me that it had been a rifle, but then once it did, here's what I did. So I appreciated that. Sarah Moxie 7 for tomorrow's energy drink. Thank you, Sarah. Thank you for the excellent educational and factual commentary, AB. Thank you for being here with me. God, there's still almost 1,000 of you here with me. 11 o'clock over here on the West Coast. Time for me to go to bed pretty soon. Get ready to do it again tomorrow, but I will definitely get myself good and caffeinated. Nazir, the conspiracies are very much flat earth, aliens, fake moon landing types, things that are possible but lack substantial evidence to back. I mean, that seems consistent with the stuff that I've seen as far as a description. It's very cherry picked, it's here's something that I don't like, or something that I can't explain, or something that seems inconsistent. It is normal for cases to have holes. It's normal for cases to have inconsistencies. It's why you look at them as a whole and not as, you don't just like hear the one thing and then turn off your mind and decide, you've got it all figured out. You have to account for everything. And I haven't heard a single theory that accounts for all of this. I'm very open-minded to the idea that this was not a lone perpetrator, not a solo person's idea that they just went off and did kind of spontaneously on their own. I'm very receptive to the idea that there was more involvement in it, but I don't know. Haven't seen evidence of that. It goes back to the epistemic humility. Are you somebody that likes to know stuff, or are you somebody that is comfortable with not knowing? There are people that are just not comfortable with not knowing. They can't sit in that space of uncertainty. And so they need to have an explanation. And then once they have the explanation, that's comforting. And so that becomes truth. I think there's plenty of that out there. I think there's a lot of kind of along those same lines, people not comfortable with uncertainty, people also not patient about allowing the information to come out. This is not going to be a fast process here in court. It is going to take a long, long time. We are going to get to trial possibly in years down the road. I mean, literally, we could be talking 2028, 2029. Not unreasonable at all. And we'll get to trial and we'll hear stuff that we've never heard before. Like, that's just the process. That's the time it takes. It's what it's for. The investigation is not done to publish it in the newspaper. It is done to take it to court so that we can all formally evaluate it at the same time, and the jury can decide what it means, what the significance of it is. Yeah, I see a lot of like theoretical, it could be this, it could be that. Like, they're like explanatory theories is what they are. They're explanatory theories. I don't want to be too, I don't want to be dismissive, I guess, like automatically dismissive of alternative theories and ideas and stuff like that. Some of them are really stupid. It doesn't mean everything is going to be really stupid. They're explanatory theories, and so that's fine. But that's like a hypothesis. It's your starting point. Once you have your explanatory theory, now you need the evidence to support it. And not only do you need the evidence to support it, your explanatory theory needs to explain all of the evidence, not just the one particular thing that led you to, have the question or have the idea about like how it could have been or anything like that at all. Great. It could have been a microphone. How do we reconcile that with Tyler Robinson being on the roof, the rifle, the bullets in Charlie, etc., etc.? I welcome a theory. Great. Tyler was involved. Where's the evidence of that? Where's the evidence of coordination? I need evidence of that to believe a fact. Otherwise, it's just an explanatory theory. And yeah, like you're saying, explanatory theories can be anything in and of themselves. They're just proof of human creativity, our ability to imagine really anything. It's kind of limitless. Take one fact and we can imagine a gazillion different ways that fact came about. Some of them plausible, some of them not so plausible. That doesn't have any relationship to what we know. That's what we can imagine. But what we know is what we can prove with evidence. So, yeah, I do. I mean, I'm trying to the extent I'm dealing with that at all. I honestly, I try to not pay attention. I don't care. I don't care. If it's a good theory, the defense is going to present it. Okay? They have by far the strongest incentive to present any good theory of factual innocence that they can come up with. So if it's there, they'll present it. JC Music Man, you mean to tell me that cases aren't like a TV show where the perpetrator explains what they did and why with everything wrapped in a neat package? But you have to first like confuse them into it, right? Yeah, but I'm just a simple country lawyer, but I always liked Ben Matlock. I liked Ben Matlock so much more than I liked Perry Mason. Perry Mason gets, it's named after him, the Perry Mason moment, the Deus ex machina they kind of have in this old style of the law shows, the sudden confession. Yes, I did do it. Rarely happens. I'm not going to say never, because you do enough trials, you see a lot of crazy stuff. A lot of crazy stuff, a lot of unpredictable stuff, a lot of stuff you didn't see coming. Trials are very, very unpredictable. So I will never say that it's never happened, but it's not common. It's just not common. Nazir, agree. Folks have to be humble enough to provide proof. If you have no proof, it's not a thing you know. It's just a thing you think. And that's fine. People can think whatever they want, but it's not a really good basis for arguing that the rest of us should share that thought. This is the reason why we rely on evidence, because it is objective. It is something that is available to all of us. We share it. And knowledge is not something that one particular person holds. If there is something that I know, you can also know it. We can all know it. Knowledge is a collective kind of asset like that. Because we can all look at the same proof, see for ourselves, come to the same conclusion. We don't have that, then all we have is your imagination. And your imagination is maybe not going to be the same as mine. All right, guys. Yeah, I did. I had a little side bet with Jeff about how long are we gonna go? Am I gonna be able to wrap it up fast stuff? I'm sure you can imagine how that went. Yes, I lost the bet. Okay, I lost. It's time for me to go to bed. It's after time for me to go to bed. I need to get some sleep so that we can do this all over again tomorrow, guys. I am planning on just continuing this format through the week. Yeah, it's going to be a busy week. Put in a lot of hours, but it is just 1 week, right? It's 1 week. I can put the pedal to the metal. we'll be back to watch the stream in the morning, and then we will do the recap in the evening show again. Nick, where you been? No red solo cups, no leaf blower. I'm disappointed. Heard from a trustworthy source. Those are excellent tools for evidence collection. None of that. Just the special wheels. Just the fancy wheels. There's always got to be something, right? There's always got to be something. Nothing is really ever new in these cases. Until it's like the thing that you've never seen before and never would have imagined happening in the middle of trial to blow up your case with your witness. That happens. But otherwise, it's like nothing is ever new. It's the same thing over and over again. It's the, yes, I'm on film doing what I'm accused of, but don't you understand it's impossible because reasons? Oh, the denial is a constant. Yeah. We did see the Stop and Shop bags show up in Luigi's case, though. Came up there, sticking his property in the shopping bag. Apparently, that one is a little bit more common than we would like. But here we just have Richard Allen's distinctive wheels on a otherwise blurry and not particularly high-res visible kind of video. So I remain skeptical. Of the special wheels. I'd like to see what the wheels are. I'd like to see, why are these distinctive? What does that even mean to you? To me, distinctive means, like, there was a period of time, as many of you know, I drive my Subaru BRZ. It's old now, but it's an awesome car. I just love this car. And there was a period of time where I wanted to do the whole mod my car thing. Real common with the style with the BRZ is what they call the Rocket Bunny. The Rocket Bunny. What a cool name is that, right? The Rocket Bunny. The Rocket Bunny is with a, they lower it and they put big wheels on it, and the wheels like extend out a little bit from the base of the car. And so sometimes you're going to have to like cut the fenders and like rebuild some of that stuff. So I looked at wheels for a while. I found this amazing, awesome racing wheel. I'd have to go find the details now for what it was. And that honestly is what killed my dream of building my Rocket Bunny, because the wheels were like $1,500 a piece, like each one. Holy, I had no idea you can pay so much for wheels, but let me tell you, they were amazing. And like they were racing wheels and stuff. So yeah, okay. But if it's just like, some non-stock aluminum rim that you can buy at Les Schwab, how distinctive is that really? I'm always going to take issue with the characterizations, because I don't know what you mean by that. And I don't know that we mean the same thing by that. I don't know that you mean the same thing by distinctive as I do. So I don't want to take your word for it. I want you to show me. Show, don't tell. Show, don't tell is always the best rule. Let me come to the conclusion myself that it's distinctive. Show me why you think that, and perhaps I will agree. But as of right now, I don't have that. So I remain skeptical. Guys, that's it. I can't take anymore. I gotta get my sleep. My cats haven't even come in to say hi to me. I think my cats even went to bed without me. That like doesn't happen. This is normally their prime time. They're not even coming in to say hi. My poor cats. Guys, it has been fun. I do again appreciate you joining me for this little recap. Letting me go down all of these rabbit holes, look at the cases and stuff like that. It's just, it always is very, very validating to me to see that anybody at all has interest in this kind of thing. Besides like the few, the proud, the many, and the public defender trenches, who are super nerds about this type of thing. You guys, a lot of you're not even lawyers, and you find this stuff interesting. So I think that's really super cool. Thank you guys. I'm going to bed. I will be back bright and early, 7:45 tomorrow. The stream should already be set up. So you can go check that, do the things if you need to do the things to get the notifications and all of that. Should be ready for you. Guys, it's been a good one. Good day one. Day one in the books. Let's see what day two brings. Exciting. Guys, see you then.